ಎಲ್ಲ ಇವತ್ತು
Court officer. Court officer. Login password. Login Zoom login. Zoom login. Zoom sir personal account. ते माझं पण दोघं नाव
ಮಾತಾಡ್ತಾ ಇರೋದು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮೆಲ್ಸಿನಲ್ಲಿ ಯಾರು ಮಾತಾಡ್ತಾ ಇರೋದು?
ಹಲೋ ಮೇಡಮ್. ಹಲೋ ಮೇಡಮ್. ಅಲ್ಲ ನಿನ್ನೆ RP ಮೂವ್ ಮಾಡಿದ್ದೆ, ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇವತ್ತು.
ಹೇಳಿದೀನಿ, ಕೇಳ್ತೀನಿ ಯಾಕೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ. ಒಂದ್ಸರಿ ವೆರಿಫೈ ಮಾಡಿಸಿ.
ಇವತ್ತೇನ್ ಮೆನ್ಷನ್ ಮಾಡೋದು ಬೇಡ ಅಲ್ಲ?
ಬೇಡ ಬೇಡ, ನಾನು ಹೇಳಿದೀನಿ.
ಅಂದ್ರೆ ಅದು 17th ಇಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಇದೆ, ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ತ್ರಾಸ ಆಗ್ತಾ ಇದೆ.
17th
ಕಂಟೆಂಪ್ಟ್ ಇದೆ, ಸೊ ಅಟ್ಲೀಸ್ಟ್ 16th ಲಿಸ್ಟ್ ಆದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
ಇನ್ನೊಂದ್ಸರಿ ಹೇಳ್ತೀನಿ ಯಾಕೆ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಅಲ್ಲಿ. ಬಿಕಾಸ್ ಅದು ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಆಗಿರೋದ್ರಿಂದ ಆರ್ಡರ್ಸ್ ತಗೊಂಡು ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಂತಿದೆ.
ಓಕೆ
ಇಲ್ಲ ಅಂತ ನೀವೇನು ಮೆನ್ಷನ್ ಮಾಡೋ ಅಗತ್ಯ ಇಲ್ಲ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Live stream. Adjournments paid by page number 9, number 44 to 47. Page 11, number 48 to 54.
Number 54.
Your appellant,
Yes.
at request of appellant, relist next week.
Page 12, number 55 to 64.
56, my lord, 56 may be taken up next week.
At request of appellant, relist next week.
Page 13, number 65 to 73.
At request of appellant, relist next week.
Page 14, number 74 to 81.
76, 76 or 78, my lord.
76, 78. At request of respondent, relist next week.
77.
Sir, ಇದು last time ಇವ್ರು ಟೈಮ್ ಕೇಳ್ಕೊಂಡು ಹೋದ್ರು ಅಪೋನೆಂಟ್ ಮೆಮೊ ಪೇಮೆಂಟ್ ಏನಂತ ನೋಡ್ಬೇಕು ಸರ್ 77 ಲಾಸ್ಟ್ ಟೈಮ್ ಇವ್ರು ಟೈಮ್ ತಗೊಂಡು ಹೋದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೆಮೊ ಮಾಡಿದ್ರು ECA ಮೆನ್ಷನ್ ಆಮೇಲೆ ಬಂದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ
Satish Chandra.
ಸತೀಶ್ ಚಂದ್ರ ಅವ್ರ ಮೆಮೊ ಮಾಡಿ
ECA matter, last time also you have taken adjournment. No, the other side was insisting to argue. He had moved the matter. ECA matter ಏನಿದೆ? Have you informed? Have you informed the other side? No, he will not be available at your whimsical time. He will not be available. You have to call him, sir. You are seeking adjournment. You can't expect him to be here anticipating that you are going to take adjournment. He's a brother advocate. You have to inform. That is a good thing. Not you will inform. If he comes and if he wants to argue, I will take up the matter. Convince him. You have to, if you are in his place, how you will feel when you are ready to matter, your client is persisting. But you convince your brother, he may agree. I will grant you time. If your brother comes and says, I am going to argue, I was not informed, I will take up the matter, hear him, give you some time. Okay? At request of counsel for appellant, release next date could you next week.
17.
What is better?
22nd, sir.
19th, 19th,
19.
19th. Request of appellant, release next week.
Page 15, number 82 to 86.
83, my lord, 83 may be taken up next week. 83.
Request of respondent one released next week.
84 million. I'm agreeing with the respondent one.
Request of respondent number one released next week. 79. Respondent number two, at request of counsel for R2 released next week. After?
29.
All right, released on 30th. 30th.
Complaints of officer session first time, seal number 1.
3 weeks time granted.
2 weeks time may be
Granted. 2 weeks time granted to comply.
Seal number 2, Gopal LT.
Counsels for the appellant submits needful is done. The same is in order, issue notice to R3, R1. What about 2.1? Other lane is ಅದ್ರಲ್ಲೂ needs to not. Sure. What is your case? Notice to R2. Who's R2? ಬೇಕಾಗುತ್ತೆ. Read this next week. Yes. Already an order for withdrawal.
Passing the interim order, there was a direction. Accordingly, it was.
So you will not press this IA. You will not. You will not press this IA now.
Yes.
IA number 2 of 19 is not pressed as respondent number 1 is claimant has already withdrawn the partial amount deposited by the appellant insurance company. Next week. Yes, 3 weeks time granted to comply.
Number 4,
Same.
number 5,
Registry to list MFA 1305 of along with this appeal.
number 6, Kirishmi Bazar,
Learned counsel for the appellant has taken out notice in respect of respondent number 4 by substitute service through newspaper publication in which newspaper?
ಹೊಸದಿಗಂತ.
No, ನೋಡಿ.
ಹೊಸದಿಗಂತ.
Wasn't Siganta of
Daily
which edition?
newspaper, Hassan district.
Hassan district. R4 is called out in the open court.
yes, respondent number 4,
No representation either by himself or through a counsel. The notice is held to be sufficient. Read this next week for admission.
number 7,
7. All right. ಯಾವ newspaper? Same. Hosa Diganta, Bangalore for R1. R1 is called out in the open court. No representation either by himself or through a counsel. Notice is held to be sufficient. This next week for admission.
I am for the appellant, my lord. I have produced the paper publication. It is published in Vijayawani.
Vijayawani Bangalore edition for R3.
Yes, my lord.
Notice is held to be sufficient. R3 called out, no representation.
Call for records, my lord.
History secure trial court records.
number 9,
Yes. ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು. Why you are waiting for her? It's your case. Notice to R1 dispense as liability is admitted by R2. Full stop. Orders on IA1. IA1 allowed delay of 101 days condoned, accepting the reasons assigned and the cost shown, which is satisfactory and bona fide. Notice to R1 dispense. Liability is admitted. Admitted? Today you want? You're ready? I'll call it after some time.
number 11, yes,
I am for the appellant, my lord. I pray for dispensation of R1, who is the driver of the corporation, my lord. It's an appeal filed by the corporation.
R1.
R1 ಇವ್ರು ಸಮಯ ಡ್ರೈವರ್ ನ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಇದ್ರ ಪ್ರಕಾರ
R1 or 6?
6 ಸಮಯ ಇಲ್ಲಿ ನಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ 6.
ಅದು ಮತ್ತೆ ನಾವು ಹುಡುಕು ನೀವು ತಪ್ಪು
ಸಾರಿ
ಹೇಳ್ತೀರಾ.
ಸ್ವಾಮಿ, ಅಲ್ಲ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ R1 ಅಲ್ಲಿದ್ರು
All
ಇಲ್ಲಿ
the stories. Notice to R6 is dispensed. As no liability is passed on to you. They have not deposited.
ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. I'll take the detail and file the memo.
Council submits 50% of the award amount is deposited. Next up, list next week for admission.
Much about.
In this case, clear for injuries, delay 55 days.
Only there. Steps of bill. Dispensation.
Dispensation happens.
Notice to R1 is dispensed as liability is admitted by R2. Next.
We finally.
2 weeks time granted to do the needful. Notice to R1 dispense as liability admitted by R2. Whether liabilities is for admission.
For the applicant,
You bring him, it's not here, dispose hang madadu.
for the applicant may not pay for weeks time to take steps now.
Weeks time granted to comply.
Please.
In this case, consequence for the responsible to
Admitted.
2 weeks time in granted.
Whether admitting the liability or not for dispensation of notice to R1. Notice to R1 dispense as liability is admitted by R2. 2 weeks granted to file objections to IA1.
Soumya,
Right.
And there is no award against her or anything. So she is not an interested party. She is not a party. After there is an objection, they get why she is not.
So you have not made party whom?
Third respondent to the that is she must be the wife of first respondent. And there is no liability or anything or any compensation awarded to her or anything. She is just a former party there. So why unnecessarily?
You have to say so. Have you said so? You have to say so. How the office will know? How the court will know?
In the this one I have.
Where is the note below the cost list, cost title?
Right.
Have you given an explanation at least? No liability is fixed,
Yes.
no claim made. Then why did you make R3 a party? Who's R3?
Actually, the wife of the first respondent to this case.
Why was she made a party before the tribunal first?
Because there is nothing. And she was made as a respondent.
Senate counsel for the appellant submits that R3 is not made a party as there is no liability as against him or her alla. No liability against her.
Third respondent in this is most of the
Accepting the submission of the Learned Counsel for appellant at the risk of appellant, notice the objection raised by the registry is overruled. Submission is accepted. Can't delete, you have to only make the amendment. It's a question of deletion. RSA deletion angry ಬರುತ್ತೆ. Don't give the order sheet. Who's no more? R2. And who's the LR? R3. Learned counsel for the appellant files a memo to treat respondent number 3 as LR of R2. Same is accepted. He is permitted to make the necessary amendment and corrections in the cost title and furnish the amended cost title by serving copy of the same on the other side. Can't delete, we have to carry out the amendment. List this appeal along with RSA 429 of 16.
Hearing on IF. Serial number 20. Chetan 80. Chetan 80.
There's no representation on behalf of appellant. Last time we did. We'll list next week.
Serial number 21.
I am for the R2, my lord.
Amended.
I filed objections for the in IF1 and the reasons furnished in the affidavit are not reasonable, my lord. They are not sufficient to explain the delay of almost 2.5 years in filing the appeal, my lords.
Claimant.
Not claimant.
You are
I'm
appearing for whom, madam?
I am appearing for the insurance company, my lord, R2.
Okay. What is the reason?
Liability has been fixed on the owner on the ground that auto rickshaw is applied outside the municipal limit area. Therefore, here recovery order can be made. And
You are for the owner. Proxy firm.
he is for the owner.
All right. Now you have filed objections or you want to file objection?
I have
Sorry.
already filed objections, my lord.
What is the reasons assigned?
He is a passenger and the respondent.
What are the reasons assigned by you for condoning the delay?
Yes. Sir. There are two of the
Some delay due to bona fide reasons.
execution file ಮಾಡಿದ್ದು very to deposit the award amount. I filed execution petition 332 of 2018 and in that execution petition the owner has stated that he has filed the appeal before December court in MF number 892070 and after approaching the value advocate in the month of March 2020 I filed also appeal has been filed.
The liability is fastened on the owner.
On the ground that the auto is explained outside the municipal area. That ground is not available to the insurance.
Learned counsel for the appellant and counsel for the respondent on IE1 of 2020. Having perused the affidavit annexed to the applications, the reasons assigned and the cost shown therein, this court deems it appropriate to allow the application to condone the delay as this court will not be required to take hyper-technical approach for condoning the delay. When applications for delay are filed in motor accident cases are pragmatic, we would have to be taken to condone the delay by imposing certain restrictions on the appellant claimant will be not entitled to interest for the delayed period. Accordingly, IE1 of 20 is allowed, delay of 835 days is condoned. However, on the claimant being successful shall not be entitled to interest for the delayed period. Yes, counsel in the connected matter committed to carry out the amendment.
It's like we scroll down. Is it included?
This proxy.
70 years back.
Is proxy counsel. Next
22.
next week ಬರುತ್ತೆ ಬನ್ರಿ.
Next week.
Huh? Next week.
22.
Next week ಅವರು ರೆಗ್ಯುಲರ್ ಕೌನ್ಸಿಲ್ ಬಂದಾಗ ಅವ್ರದ್ದು ಏನು ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ ಅದು ತಲೆ ಗೊತ್ತಿಲ್ಲ ಕಾಲು ಗೊತ್ತಿಲ್ಲ. No, but it will not be justice on his part to argue his brother's matter.
2.
Yes. Delay can be condoned.
The advocate for the appellant, this is a case of death. Delay may be condoned and it may be posted for admission next week.
2020 is allowed accepting the reasons assigned and the cost shown, which is bona fide and sufficient. Delay of 4 days condoned. Claimant, however, claimant on being successful shall not be entitled to interest for the delayed period. List for admission next week.
23.
Yes.
Who appeals by the insurance company, and who appeals by the pregnancy enhancement? My appeal is on the ground of liability and quantum, I'm restricting the nature of increase and the disability aspect. So PCR may be required.
Condone the delay. Stay is granted or not yet?
Still granted.
Granted. Yeah, again, I is listed for stay.
It's,
Granted. We'll call for records.
yes. If I-
Orders on IA number 1 of 21. Application is filed by the insurance company to condone the delay of 155 days in filing the appeal. Those orders will be same in both. Both are 155 days. Well, having perused the affidavit annexed to the application, being satisfied with the reasons assigned, the cost shown therein, the delay requires to be condoned accordingly. It is condoned. IA number 1 of 2020 and IA number 1 of 21 is allowed. Delay of 155 days is condoned. Full stop. Orders on IA number 2 of 21. There shall be stay of operation and execution of the judgment award dated 2/3/20 passed by the MSCT Mayor Hall Unit SCCH 19 in MVC 6037, subject to the appellant insurance company depositing 50% of the award amount. In both the cases,
Yes, fine.
before this court, along with interest, within 4 weeks from today. Registry to secure trial court records this next week for admission.
By the which is the liability and owner. I was notice for not served and the owner of the vehicle. Therefore, I tried to review the issue. It was in which the notice for the issue. That one more like the RP number my 32 of
Filed by insurance company, appeal was allowed.
it was allowed. Later, I am the owner of the vehicle.
What, madam?
I have not tried it. Okay, some of the company.
Arising out of the same accident.
Same as. There were 3 injured persons. And then in another case, the same insurance company filed an appeal.
3 claimants, huh?
3 claims, separately.
One of them were the image of the car made with an accident. According to me, the car was taken on road without a permit because it was a motor car. And there were 2 claim petitions.
All right, we'll list that also on here. List RP number 532 of 2022, along with this, these appeals. Yes,
Number 24.
claimant, copy ಕೊಟ್ಟಿಲ್ಲ. ಕೊಡಿ ಅವ್ರಿಗೆ. You have serious objections on IE? That counsel for both parties are present. Appellant to serve one set of copy along with documents to the respondent number 2. Huh? ಅದರಲ್ಲೇನು? ಸರ್ವ್ ಆಗಿಲ್ವಾ ಅದರಲ್ಲಿ? So you'll take notice. Learned counsel Sri Ravi S. Samprati accepts notice. Is directed to take notice for R2 in the connected matter MFA 3260 of 21. Registry to show his name in the cost list. Notice to R1 is dispensed as a liability is admitted by R2. Full stop. Orders on IA1 of 21 in MFA 2905. Having perused the affidavit annexed to the application being satisfied with the reasons assigned and cost shown therein being bona fide, the application is allowed. Delay of 224 days is condoned. Claimant, copy ಕೊಡಿ ಅವರು.
25.
You are for?
And
One and two.
Yes.
Insurance company.
Yes.
All right. Any serious objections on IA? Really? Not interested. Learned counsel for both parties are present. Learned counsel for the respondent 1 and 2 submits that copies of the appeal memo and documents are not furnished to him. Learned counsel for the appellant to furnish the copies of the appeal memo along with documents. Release next week. Next week. Maheshwarappa. Claimant. Claimant. A1 of 21 allowed delay of 53 days condoned. Registry to secure trial court records.
27.
Six
6337 of 23. Registry to list this matter along with MFA 6337 of 23. Issue notice. D. Pradeep is directed to Learned Counsel is directed to take notice for R2. Issue notice to R1.
28.
Secure trial court records.
28.
Issue notice to respondent. Issue notice to respondent.
30.
Rangigoda. Issue notice to respondent. Notice to R1 dispense as liability as admitted by R1. Memo accepted.
31.
Issue notice to respondent. Notice to R1 is dispensed as liabilities admitted by R2. Memo accepted. Yes, Mr. Gurudev, 118 days delay. Issue notice to respondents.
Appearing for appellant, my lord. There is a delay of 532 days.
Notice respondent. Notice to R1 dispense as liability is admitted by R2. Issue notice to R2. List along with 3566 of 23. Issue notice.
Appearing for appellant, my lord. 195 days delay, my lord.
Issue notice to respondent.
Much of this.
Huh? Notice to R1 should be dispensed. Admitted by R3. Notice to R1 and 2 dispense as liability is admitted by R3. What is this IA1 CD may be necessary? Necessary or not necessary? It may be necessary. So you have already filed IA1. So I'll dismiss as not pressed. IA1 of 23 is dismissed as not pressed as appeal is in time.
Okay.
I am for the respondent, respondent of B and A and C. Whether I am disputing the relationship. Gallas of 3B, he is not the wife of MP Nagar. I filed objections. Correct. 3B is not the wife of MP Nagar. I have put in the date. She is the wife of one Lakshmurti. I have put in the school. Quite detailed objection regarding LR enquiry is going on. Is pending in respect of YS number 165 or 2014 on the file of the civil judge at Kudu. You are disputing the relationship. She is not the wife of MP Nagar.
Yes, what do you say? Counsel for the respondent seeks release next week. Next week. He doesn't know. Let us senior come. What about 38.1? Same. How many suits are there?
In respect of others, only in respect of 282 I am.
In 798 Nivilla. Release next week.
Notice connected. IML.
You are appearing for appellant, first matter only. Or
38, I am the applicant.
you have interchanged yourself.
38, I am the disease respondent number 3,
All right.
A and C.
All right. In the connected matter, notice has to go. Issue notice on IA and main.
39.
Independently after Administration, they have 17 days. Number 2, NOCR now we will NOCR previously. And deleted enhancements. My name is already.
So it's not admitted. Now then dismiss for non-prosecution. (29/5/23). When was it admitted?
17,
29.
22.17.
Counsel for the appellant has filed an application under filed application IA number 1-2 of 2023 to recall the order dated 29/5/2023 by condoning the delay of 17 days in filing the said application. As far as the affidavit annexed to the application being satisfied with the reasons assigned and cause shown therein, considering the fact that the second appeal was admitted on 22/2/2017, matter requires to be considered on merits. Accordingly, the order dated 29/5/2023 dismissing the appeal for non-prosecution is hereby recalled, condoning the delay of 17 days in filing the said application. This matter for hearing. This matter for hearing. ನೀವು ಇರ್ಲಿಲ್ವಾ ಲಾಸ್ಟ್ ಟೈಮ್? ಹೇಳ್ಬೇಕಾಗಿತ್ತು ನೀವು ಕೋರ್ಟ್ಗೆ. ನೀವು ಇರ್ಲಿಲ್ವಾ? Delete name of SP Lakshmi. Your Shashidhar.
Yes.
Registry to delete the name of Leonard Counsel SP Lakshmi from the cost list. Sridhara.
40, K. Ravishankar.
Ariga. 17 order, now you are filing. 17. My counsel for the appellant has filed IA number 1 of 17 to recall the order 31/8/2017, wherein this court dismissed the appeal for non-compliance of the objections raised by the registry. What is the objection? Being satisfied with the reasons assigned and cost shown in the application, which is on time. The IA number 1 of 17 is allowed, order dated 31/8/17 is hereby recalled. Matter is admitted or not? It's been recalled. The appellant is permitted to comply with the objections raised by the registry within 2 weeks. Failing which the appellant, this order would not inure to the benefit of the appellant.
41. Nagarajan. 41.
No representation on behalf of the appellant. We just next week.
42, A. Anand.
Leonard Counsel for the appellant on IA number 1 of 18. IA number 1 filed to condone the delay of 98 days in filing the application to recall the order dated 30/8/2017. There is the affidavit annexed to the application and satisfied with the reasons assigned and cost shown. Appeal. The order dated 30th August 2017 is hereby recalled. Appeal is restored to its original file. 2 weeks time granted. Granted to the appellant. Comply with the objections. Raised to the registry. Suit for? You don't comply despite conditional order.
Recently, this appellant passed away. Passed away. Thereafter, wife and yes.
Who's dead now in this case? Who has died? Robert is which Robert now? Robert is plaintiff, respondent, defendant. Who's he?
Number 17.
Third learned counsel for the appellant on AE number 1 and 2. He is satisfied with the reasons assigned and first shown in the affidavit annexed to these applications. Court deems it appropriate to allow the applications as the appeal came to be dismissed for non-compliance of the objections raised by the registry. Accordingly, order dated 9/8/2017 is hereby recalled. Appeal is restored to its original file. Delay of 231 days in filing the said application is condoned. Subject to the appellant depositing rupees 2,500 to the High Court. What is that? Liability?
Clerks Association.
Huh?
Clerk Association. Advocates Welfare Fund.
Advocates Clerks Welfare
Welfare
Fund.
Fund.
Compliance, the appellant shall comply with the objection within 2 weeks. Deposit of the amount is subject, condition precedent. Deposit of the amount is condition precedent.
Email office objection.
ಅದೇ ನಮಗೆ ಎಲ್ಲರ
ಅದು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಬಗ್ಗೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಹಾಕೊಂಡಿದೆ.
ರೆಸ್ಟೋರ್ ಆದ್ಮೇಲೆ ನಂತರ. Then there is some objection on this, your eye. Yes, Mr. Vishwanath Pujari. Because already one G1K has filed wakalat. When did you file wakalat? March 20? 2020. 23. What about G1?
2/1/2023.
He's earlier. Deleted. Or you find out whether he's going to appear or not. He's not going to appear, you can appear. Because he's not present here also. If he doesn't come, you don't come, your client will be affected. I list it next week. No representation on behalf of applicant. Counsel for R2 is present, relist next week. Chetan, Hegde, Mulkhand. No representation on either side, relist next week. Padmanabh,
The advocate for the appellant, I may be permitted to issue notice to any standing counsel for R3, Shriram General Insurance.
Sriram General, Vishpendraya, Sriram General, Nivilva, Pradeepa. Learned Counsel Sri Pradeep B is there to take notice for R3. Registry to show his name in the cost list, copies to be served on him. Relist next week.
47.
Yes, Mr.
R3. Third respondent returned to Shara, but party refused.
That is to R3 now. The postal sheriff notice issued to R3 is returned with Shara as refused. Is returned with the endorsement as refused. Hence, the notice is held to be sufficient for R3 in 47.1. What about others?
47.3 and 47.4 also the same, my lords. Respondent
1, 2, and 4. Same order 1, 2, and 4. 3 ಎಲ್ಲೋ ಇದೆಯಲ್ರಿ? ಮತ್ತೆ ನೀವು ಹೇಳ್ಬೇಕಲ್ಲ, ನಾವು ಹುಡುಕ್ಬೇಕಾ? Sir, you please tell in which all he has admitted. You have to say which all this order has to be passed. You want the court to search. Madam, 47.1, 47.2, 47.3, 47.4. Notice to R3 is held sufficient. Yes.
My lords, in 47.5 I need to take steps, my lords. I'll take steps.
Otherly,
47.5.
steps to be taken in 47.5. Weeks time granted. Registry to list MFA numbers also along with these appeals. Write it in a piece of paper.
48. Yeah.
You are ready?
Motorcycle came from same direction in a rational and manner by suddenly taking a sudden left turn dash against the traffic. Due to the impact, they have been gone over the transmission. And after investigating police of that country, read the report. Expect info as part of the station. The person was crossing the road from east to west. After crossing the main road of the road, motorcycle in person came from behind in a rash and negligent manner by suddenly to get sudden left turn and dash. The red is not exactly. The appellant was crossing the road where there was no zebra crossing operation. In nowhere in the road, either a pedestrian person is there or zebra crossing. That way, 8 main road in the Anand line. Nearby the road, There is no pedestrian crossing. After crossing the major force in the same direction, motorcycle in question came from behind in a rash and negligent manner. While taking a sudden left turn, dashed against the motorcycle.
Where were you standing?
Crossing
You are crossing the road.
the road in east to west. After crossing more than 50%, vehicle in question came from same direction
Hmm.
in a rash and negligent manner, dashed against the
Contributory negligence is there or?
25% is directed towards contributory negligence, saying that the applicant was crossing the road where there was no pedestrian crossing.
Records are there?
Yes, come.
All right. Yes. What's the evidence?
Yes.
What is the evidence that she was crossing the road and
Before spots.
what was the signal at that point of time?
There is
No signal.
in basic class and there is no signal.
Hmm.
One has to cross the road after seeing the process.
What's the age?
Age of the applicant was what 60 years. 56 years at the time of the accident. Absent element in the year 2018. Applicant has sustained fracture in neck of left field. She was treated as inpatient for 17 days. In Sanjay hospital. And underarm surgery, open and tissue was done. After complete treatment with the permanent disability to the extent of 19% of the whole body. Given has taken 7% the last funding capacity. And paying suffering million. Only 15,000 is awarded.
What is the disability assessed by the doctor?
19%. Whole body.
What is the particular limb?
Limb disability is not assessed in the whole body.
What is the injury?
Fracture next to left human. The major.
Yes.
Here they are taking from 80. People has taken 8,500, 20,500.
8,500 ತಗೊಂಡಿದೆ.
Instead of 12,500. And injury payments, only 15,000 is awarded. Last amenities and nutrition food, only 10,000 is awarded. Conveyance,
Medical expenses correct?
as per bills. 72,000 is awarded. I produced the bill.
Amenities?
Amenities only 10,000 is awarded, including the nutrition. Attendance charges and conveyance. So was inpatient for a period of 17 days. Thereafter, she has taken about occupied more than 6 months. Only 5,000 is awarded.
All right. What's the
Laid up. Only
What's the
8,000 is awarded.
chart value? Chart value is 3.
12,500.
Yes, that's all.
Except medical expenses. All the kids are required for reconsideration.
Yes. So on the 25% contributory negligence, what is the reasoning of the tribunal?
The reason when the applicant was crossing the road, where there was no pedestrian crossing.
Read that, which is that portion?
Page 5. Page 6, paragraph 12. Paragraph 12. In the process he has explained that her husband was lodged a complaint and he is also a witness to the accident as he was coming behind her. She didn't that the accident took place in the middle of the road, but admitted that there was no zebra crossing or pedestrian crossing. We had to place of accident. She further did that the accident took place in the public. In rebuttal, the respondent has examined it as argument and concluded that there are not liable to pay the compensation. The cross-examination of argument shows that the and the vehicle moved in the same direction. And it was for example, you have ever to any zebra cross near the accent. It is considered the judgment is quite against the rest of the section. But any of the persons have crossed the opposite. Based on this evidence, the counsel for the procedural argues stating that there was no zebra cross near the place of participant. And the person has to cross the route for crossing the road without any argument. Therefore, the negligence is on the part of the right motorcycle who failed to take a key care while riding such motorcycle. On the contrary, the counsel for the respondent argued that the prisoner has also concluded as she moved where there is no pedestrian cross or zebra. The rider of the motorcycle is not examined. Except as options. Document clearly because of the motorcycle in question came from the same direction from wicket to the plane. There is no contributory like on the part of the.
So,
Negligence is concerned.
the record code is which code? Yes.
Exhibit P4 of the page, will not be technically the action. The statement is the 25% of the last year.
Oh, it is almost in the middle of the road.
She was crossing the vehicle, motorcycle came from same direction from her behind. When taking a left turn.
Same direction, Barbarda.
Purpose.
Huh.
He had a.
It's a road, sir.
Avoid the accident.
No, it is not a park. It is not Kaban Park for you to walk around when the vehicles are flying. You have to be also diligent.
He had a. Avoid the accident.
You had opportunity to stop.
I already crossed.
This attitude should stop. You can't put the entire blame on the rider of the vehicle. It's a road. You have to see. Even when you are a child, it is shown. See left and right and then cross the road. You have crossed the road. Your state stated there is no zebra crossing also. You are not allowed to cross the road when there is no zebra crossing. First of all, you are not supposed to enter the road when there is no zebra crossing. How you can cross the road? Huh?
If there is no zebra crossing or pedestrian crossing, one has to cross the road.
Then you have to file a case against the state. You implicate the state. I will award damages against the state. They should have provided for you some way to cross the road. If there is not provided, you are not supposed to cross the road.
When I entered into the road, there was no vehicle.
First of all, you are not supposed to enter into the road, Mr. Girmallaya. Adu road adu, park alla, ನೀವು ಸುಮ್ಮನೆ ಓಡಾಡಕ್ಕೆ. Then you, contributory negligence is correct on your part by the tribunal. Even according to you, there is no zebra crossing.
Where there is no zebra crossing either near the place action. In this circumstances, one has to cross the road after seeing the both sides.
All right, yes.
25% on the last year, there will be some reduction in conflict, but she has contributed to the accident. And apart from that, your loss mechanism, the doctor has not assessed the disability to achieve. He can assess the disability to live and the whole body activity. So, 19% can be fixed somewhere in the range of around 12 to 15%. For the whole body disabilities.
No, there is a disability of 19% by the doctor.
So the whole body from the lower limb. Here, normally doctor will assess the disability for the limb. Hereafter, they convert the disability whole body, the limb disability to whole body disability. But here are not assessed the disability to the limb.
That is your cross-examination.
If you have assessed the physical disability, I am not considered okay. It is true that the case petitioner is diagnosed with one case of diabetes. It is true that we mentioned history in the case sheet. It is true that it is also there that the discussion of the movements observed observed or not found in the case sheet, it is not to be addressed. It is
But
not-
either way, Mr. Samprati, you have not filed appeal.
No, I am.
He is only in appeal.
Yes.
So that cannot be.
Court of convenience, 100% disability. The doctor has not addressed the whole body disability, the limb disability. That is the reason why the whole body disability is converted into, the limb disability is converted into whole body disability. That's 100%.
What is the disability according to you?
19%.
No. What are the fractures? What is it?
Neck of pain. Major. Sustained fracture, neck of pain.
Then he has put total permanent disability to whole body from left lower limb.
Left lower limb. 19%, the whole body, left lower limb.
ಆಗಿರೋದು neck, left lower limb 19%.
Here,
Hip joint,
neck of femur.
neck of femur, not the neck, neck of femur. What was he working as?
Doing a tailoring work and it's 15%.
No proof of income.
No proof. Also required.
Yes, what is the doctor? Why you have not cross-examined the doctor?
But the suggestion was put to the doctor and the field consultant. It is not proper to suggest that it is compared with 1/3 to the whole body. We deny that. We deny the protection. We deny the protection that 19% was not the whole body, but we deny that.
That's all.
That's the only person who is in national. Part of the trial.
Purple. The appeal is preferred by the claimant. Challenging the judgment and award of the Motor Accident Claims Tribunal's Court of Small Causes, Bengaluru, in MVC 7500/2018, dated 22 October 2019. This appeal is founded on the premise of inadequate and meager compensation awarded by the tribunal. The facts of the case. On 21/11/2018 at 9 p.m. The appellant claimant was crossing the road crossing 7th Cross Road near Nirmala Stores, Hanamantanagar. At which time a rider of bullet motorcycle bearing K01EN 8423 came in a rash and negligent manner and dashed against the claimant. Due to the impact of the accident, the claimant suffered grievous injuries. She was taken to Sanjay Gandhi Hospital for treatment, where she was inpatient. Adralle 70 days for 17 days and underwent open reduction and internal fixation surgery. It is a case of a claimant that she was feeling healthy prior to the occurrence of the accident. She was doing tailoring job,
Yes.
earning 15,000 per month. due to the injury suffered in the road traffic accident, she has become partially disabled and she has filed claim petition seeking compensation against the respondents. On appearance, respondent filed statement of objections denying the negligence on behalf of the rider of the motorcycle and attributed the negligence on behalf of the claimant who was crossing the road without following the proper rules and regulations. Respondent number 2 filed statement of objection to absolve his liability in view of policy being enforced with respondent number 1 and sought for dismissal of the claim petition. The tribunal framed relevant issues for consideration. In order to substantiate the issues and establish the case, claimant examined herself as PW1, produced exhibit P1 to P11. Mr. Claimant also examined doctor as PW2 and got marked P12 and P13. Respondent examined his official as RW1. No document was marked. On the basis of material evidence, both oral and documentary, the tribunal awarded total compensation of 1,75,000 with interest at 9% from the date of petition till deposit, and held both respondent 1 and 2 to be jointly and severally liable to pay the compensation. However, directed the insurance company to deposit the compensation as the policy was in force as on date of occurrence of accident. The vehement contention of learned counsel for the appellant that the tribunal has committed an error in awarding meager compensation without taking into consideration the materials placed on record and has ignored the aspect of the evidence adduced by the Dr. PW2 with regard to disability to an extent of 19%. Full stop. He also contends that the tribunal has committed a serious error in fastening 25% contributory negligence on the claimant who was a pedestrian. It is also contended that under other heads also the tribunal has awarded meager compensation, which calls for enhancement and seeks to allow the appeal. Per contra, learned counsel representing the insurance company contends that there is no illegality or perversity in the award passed by the tribunal. He sustains the order of the tribunal and the fastening of 25% contributory negligence by contending that it was a road and the accident has occurred almost in the middle of the road. The claimant pedestrian should have been careful while crossing the road. Admittedly, it was not a place designated for crossing the road or where zebra crossing was provided for the claimant to cross the road. Therefore, the assessment and calculation of the tribunal attributing 25% contributory negligence against the claimant is correct, and the same does not call for interference. It is also contended by learned counsel that under other heads also the tribunals awarded reasonable compensation which does not call for interference. Accordingly, he seeks to dismiss the appeal. I have heard learned counsel for both parties. There was the impugned judgment and award and look through the original records. It is not in dispute that on 21/11/2018 at 9 p.m. while the claimant was crossing the 7th crossroad near Nirmala stores, the motorcycle, the respondent number 2 came in a, ridden by the rider, came in a rash and negligent manner and dashed against the claimant. FIR charge sheet is all against the rider. In order to establish these aspects, the claimant has produced exhibits P1 to P7 being the police records and P8 to P13 being the medical records. The police records show that a criminal case has been registered against the rider of the offending vehicle, which is not disputed and which is not challenged before the appropriate forum. Therefore, charge sheet has also been laid against the rider of the offending vehicle. Full stop. Negligence to the extent of 75% is attributed against the rider of the motorcycle and 25% against the claimant. Though it is vehemently argued by learned counsel for the appellant claimant that the entire negligence is to be fastened on the rider of the motorcycle, as he should have been careful while riding the motorcycle. And when admittedly there was no pedestrian cross or zebra cross at the place of occurrence of accident when the claimant crossed the road on the 7th cross near Nirmala stores. So if the claimant attributes the entire negligence against the rider of the motorcycle. On the contrary, it is seen that as per the sketch exhibit P4, the accident has occurred in the middle of the 7th cross road. When there is no pedestrian cross or zebra cross, it cannot be said that the pedestrian or a person who's walking by can suddenly cross the road. It is a fundamental principle that the pedestrian will have to cross the road only at a designated place provided for crossing the road. It is also the responsibility of every citizen while crossing the road to look into the left side and the right side before crossing the road. And that also has to be done on the place designated for crossing the road. If no such place is designated, it is to be very carefully negotiated by the pedestrian while crossing the road, and entire negligence cannot be attributed against the rider of the motorcycle if any untoward incident happens. Considering the facts and circumstances in the present case, the tribunal has fastened 25% negligence, which according to me is on the higher side, against the claimant. I'm in agreement with the learned counsel for the claimant partially to reduce the contributory negligence as against the claimant. Full stop. Accordingly, the contributory negligence against the claimant is attributed at 10% rather than 25% fixed by the tribunal. The fan on. PW2 is the doctor who has examined the patient claimant and assessed disability to an extent of 19% to the left lower limb. However, the Dr. PW2 has not assessed disability to the particular limb, except stating whole body disability to an extent of 19%. Tribunal not being satisfied with such disability assessment made by the doctor has assessed the disability to be 7% rather than 19% expressed by the doctor. I'm in agreement with the learned counsel for the claimant that the disability assessed by the tribunal is on the lower side, considering the fact that the doctor has not assessed the disability to a particular limb as prescribed in the medical manual, a government notification. Government gazette notification. The disability, however, there is certain disability. The same is taken at 15% rather than 19% in view of the injuries sustained by the claimant as explained by the doctor PW2 and the X-ray produced, and there being a neck of the femur of the right side being previously injured. Left side. Neck of the femur of the left side is previously being injured. The claimant was aged 56 years age on date of occurrence of accident. The appropriate multiplier would be 9, which is rightly taken. Same does not call for interference. The tribunal has assessed the income of the claimant to be 8,500 per month, whereas Legal Services Authority chart, notional income chart for the accident year 2018 prescribes 12,500 per month. Same is taken as income of the claimant. In view of the same, the loss of future earning capacity due to disability would be 12,500 into 12 into 9 to 15. 2,25,500. 2,02,500. 12,500 into 12 into 9 into 15%. As against 64,260 awarded by the tribunal. Towards pain and agony, tribunal is awarded 15,000. This court deems it appropriate to award 25,000 under this head, as against 15,000. Towards medical expenses, it is awarded on actual medical bills produced by the claimant, same is not disturbed. Towards loss of amenities and nutritious food, tribunal is awarded 10,000. Additional 25,000 is awarded under this head. Towards attendance charges and conveyance, tribunal is awarded 5,000, whereas the claimant was inpatient for 17 days. An additional 20,000 is awarded under this head. Towards loss of income during later period, tribunal is awarded 8,000. In view of this court enhancing the income from 8,500 to 12,500, at least 3 months period would be required for recuperation and to get back to normal day-to-day work. 12,500 into 3 would be 37,500 under this head. So, whether doctor says doctor has to say so. Towards future medical expenses, though the doctor has not opined anything, the fact remains that the claimant has undergone certain surgeries where implants are put in situ. Therefore, the same requires to be removed, for which 25,000 would be reasonable amount to be awarded towards future medical expenses, which would not carry interest. And in view of the above discussions, claimant would be entitled to total compensation of as against 1,75,000 awarded by the tribunal. All other terms and conditions imposed by the tribunal stands intact. Huh? Yes. The claimant would be entitled to pay total compensation of 4 lakhs
27,000.
less 10%. Mr. Madhu, 4 lakh 27. 7.
757.
4 lakh 27, 757. 3 lakh 84, 982. 3 lakh 84, 982. They have to, the respondent insurance company is liable to pay compensation of 3,84,982. Should it be 90% of the total compensation amount in favor of the claimant. The enhanced compensation amount would carry interest at 6%. All other terms stipulated by the tribunal stands intact. The entire amount, enhanced compensation amount shall be released in favor of the claimant upon proper verification.
So 49. Additional. Was mainly working on the side of the road lots, where the respondent number one, because motorcycle had come and collided with. Because of the season, he had a major injury in his knee or lots in his left knee, which resulted in 27% disability. Lodge, he was admitted in the hospital and an operation was conducted. Thereafter, he had to attend to regular physical therapies. Thereafter, he was even after that, he is not completely recovered and still he suffers from 27% disability. But at the time when the accident occurred, he was working as a postmaster. So his daily job was by walking and delivering post. Because of the fact that he incurred this injury, he is no longer able to work as a postmaster. The reason why we have filed the MFA is because despite the fact that the doctor who operated on him and also provided a disability certificate 27%, the court has only taken disability to be 9% in the case.
What the doctor has said?
The doctor has disability certificate. Marked as exhibit P69, and he was also cross-examined your laws. He said that there was 27 disability in his lower limb locomotor function permanently your laws, because of which he will no longer be able to do any jobs which he was earlier being doing your laws. Because moreover, he also owned a small piece of land in which he worked as an agriculturalist, and because of this disability now, he's not able to work even as an agriculturalist in a small piece of land. Because of which now he has a total loss of income. But he was 57 years old at the time of the accident, so he had a good 8-9 years of service life. So the grounds we have filed the appeal and we are now seeking to reform.
He's getting the pension.
Yes, sir.
He's getting pension.
No,
Postmaster pension barala.
Not permanent.
Not permanent employee.
he was a temporary postmaster at that time. But because of the season, he is no longer a postmaster. And he was an agriculturalist also.
Have you produced a document of his income, proof of income? It is postmaster andre. He is the head of the post office.
He is postmaster, temporary employee, but he was continued when he was extended to 57 years. With the retirement of the only 60. was continued job till 16. Future was happening for granted by the tribunal and also future was not granted.
Future prospects granted.
What is 27% comes to 9%. 9% is a 9% taken by the advantage.
So 11,000 is the amount.
11,000 taken by the income is correct.
The 11,000 is only taken considering the fact that it's working as an agricultural source. The 11,000 rupees has been taken as additional income for the agricultural work. The low one is not at all considered the fact that it was also working as a temporary postmaster at that time.
There is the income proof.
No, there is no income proof.
They are not produced.
There is no income proof for.
Why?
Because that is not produced.
All right, if you have now, produce it. But I'm having 27.
Our future passport is not right, but 10%.
Why this 10% is given?
Not correct. 20% is also is entitled.
Huh?
20% more money is limited consent is 20% each one of them is entitled to future prospects as per the judgment of the Lord. Now,
As per the judgment of?
judgment is the Lord judgment is other prakara whole body disability 20% each one of them they are entitled the choice. In this case, doctor deposed limb disability 27%. Then they taken the 9% is the whole body. Therefore, he is not entitled the future person.
Which is this judgment which is 20% bandre you can be given?
And DK, but the
20%. 20%.
20% whole body equal. For example, limb disability 60%. Divided by 100 comes to 20. If the 20%
More than 80%. I think I remember what I have read. More than 80%.
It is there.
Yes,
Excess 20% is legally 20% illa. Therefore, future cost of is not right.
All right.
When we seek instructions from the petitioner with regard to is any bank statements are available to prove his income and maybe allowed to do that.
Would it be more than 11,000?
Yes, 11,000 was
Was he earning more than 11,000?
yes, but he was earning 15,000 rupees as his master.
They are not considering it text.
Not for this job.
Another document. Release next week. Request. You should not argue the matter when you are not ready. Why you started argument and wasted the time of court? You should check with your client and know what is the law first and then come and argue. This is High Court. You will not have, your client will not have the privilege of going to the Supreme Court challenging this order. Later on, if you find out that he was earning more than 25,000. ಕಳಿಸ್ಬೋದಾ? Krishna Swami idara? He is agreeable? Learned counsel for the appellant is present. Submits that the matter could be referred to the Lok Adalat. There will be a sitting of Lok Adalat on 16th. 16th, in this court itself at 4:45. I list it on that day. List this matter on 16th at 4:45 p.m. before the Lok Adalat.
My lord, I am for appellant. Claimant's appeal for enhancement. My lord, actually respond to B. Pradeep is directed to take notice and I served the copy. Wakalat not filed, it seems me.
The learned counsel for appellant is present. No representation for respondent. Release next week. for admission.
52.
Right.
Withdraw.
No representation on either side. Release next week. Shantaraj, yes, sir.
You go jail about 35 years.
You are ready, sir. You are always ready, but your friend is not here.
Mohan Kumar is also, yes, he is ready, but he should have been appeared in EDC.
Kare aur hesaru kare. Yaar Mohan Kumar.
Mohan Kumar.
Mohan Kumar. Bandidara. Ivat bandilva. Have you seen him today? Which insurance company?
United.
ಮುಂದಿನ ವಾರ ಹಾಕೋಣ or ಇಲ್ಲ? If you want to wait, I will pass over.
You used to wait to my Your point is that 7,080 was an 18 accident. As per chart, it has to be taken.
12,500 ತಗೋಬೇಕು. Why don't you prepare one memo and give?
Yes, certainly.
You can exchange to your friend. Before you come to the court, when you sit, you can exchange with that memo of calculation 12,500 into 12 into so and so. One small 1-page A4 size memo.
Yes. Here in after.
ಯಾರು ಮಾಡ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. So one
easily.
The claimants or even the insurance company prepare one A4 size memo. Because only thing is there will be income which will be notional income difference. Notional income will change. Into 12 will be common. Multiplier will change. And disability may change. Nim column on madi, our column on blank bidi. Or ಏನಾರ ಇದ್ರೆ ಅವ್ರು ಬರ್ಕೊಡ್ತಾರೆ. Agreeable ಆದ್ರೆ we can, that will be faster. Nothing is there. It is all mathematical calculations. Court time waste ಮಾಡೋದೇ ಬೇಕು. Lok Adalat ಎಲ್ಲ ಮುಗಿಸಬಹುದು. Gross time is wasted here before this court. Instead, this court can perform other better job. Whether it can be referred to Lok Adalat. Counsel for the appellant is present. No representation for respondent. Release next week. Yes. Shivanna Gowda. Lingaraj is not here. Not here. On the release next week at request of our respondent. All right, Wednesday. 17. You prepare ಮಾಡಿ. Prepare a memo. ಕೊಟ್ಟಿದ್ದೀರಾ? Yes. Shivanna Gowda. Naik. Ready? Date of accident? ಒಬ್ಬರೇನಾ?
Personal deduction 50% instead of 50% 1/3 deduction.
So tribunal has made 50% deduction. 1/3 ಮಾಡಬೇಕು.
Income is considered made up within 9,000 rupees. Send 18.
9,000 ತಗೊಂಡಿದ್ದಾರಾ?
10,000 plus 10% future.
So 2018, 12,500. ಕೊಟ್ಟಿಲ್ವಾ? What is the age?
Here, 55 years at the time of.
So 55 years is 25%. 10%.
and multiply by the bank.
And what about consortium? 70,000.
Instead of that, income of the
Escalation ಕೊಟ್ಟಿದ್ದಾರೆ 10%. So that will be 44,000 plus 33.
question is not.
So 44 plus 33. Stay enough. Good.
9% interest is 9% interest study. Enhancement.
You are not in appeal.
For enhancement.
Enhanced income. The compensation. Otherwise, tribunal is given 9%.
Then
The accident is occurred on 10/4/2018. The age of the deceased as on the date of occurrence of the accident was 55 years. Tribunal has taken the income to be 9,000 per month, whereas the notional income charge stipulates 12,500 per month to be the income for the accident year 2018. Tribunal has awarded 10% future prospects. Is correct, which does not call for interference.
section of 50%. 50% is short character.
Tribunal has deducted 50% towards personal and living expenses, whereas 1/3 ought to have been taken as one dependent,
Only one way is independent.
whereas the wife is dependent, and since the deceased was married, 1/3 would have to be deducted as against 50% adopted by the tribunal. The appropriate multiplier would be 11, which is correctly taken. Same does not call for interference. $12,500 means loss of dependency would be 12,500 into 12 into 11 minus
Less than plus 10%.
one నిమిషం cancel 12,500 plus 10%, 13,750. So 9167 ತಗೋಬೇಕು. 13,750 minus 4,583 is 9167, which is the income to be taken of the deceased for computation. Into 12 into 11 would be 12,10,044 as against
As a result, 6 lakh.
Which page it is? Partition should burden as against 6,53,400. Tribunal is awarded consortium to an extent of 40,000, loss of estate 15,000, loss of towards funeral and transportation expense 15,000, medical expenses on actuals 2,700. Same does not call for interference except an addition of 10% escalation as stipulated in the case of Pranay Sethi on consortium and conventional head, which would be 44,000 and 33,000, as against 40,000 and 30,000. In view of the above discussions, claimant would be entitled to total compensation of 2,700.
1,89,744.
1,89,744. 744. Correct. 12,89,744 as against 7,26,100 as per the table below. Accordingly, a pass of following order appeal is allowed in part. Judgment is modified, claimant is entitled to a total compensation of 12,89,744. All other terms of the tribunal stands intact. And respondent insurance company shall pay the balance enhanced compensation within at 6% interest within 4 weeks from the date of receipt of copy of the order. Enhanced compensation 6%.
Adjourn. Serial number 57.
That is your friend. Pradeep colleague Referral. What's his name? Mallikarjun Elli. It's also death case. Huh?
2016 accident.
Just ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾವ ವರ್ಷ ಆಕ್ಸಿಡೆಂಟ್? 2016. What is awarded by the tribunal? Income ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? So 9,000 ಬರಬೇಕಾ? 500.
10% future.
Age?
56 years.
Dependents? ಒಬ್ರೇನಾ?
50% deduction ಮಾಡಿದ್ರ.
Major son. So 50% is correct. Request ಮಾಡ್ಬೋದಾ? ಬರ್ಬೇಕಾ?
Major son. Under 80% company. But according to Manohar, they are entitled only the last attested to the extended terms. But it's already granted, they are not in the office, therefore award the status by. They require I will build it for that no permission, build it for the order.
This appeal is preferred by the claimant challenging the judgment and award passed by the MACT CH-18 in MVC 7518 of 16 dated 17 September 2019. Brief facts of the case. On 20th March 2016, while a lady, that Madamma, Srimati Madamma, was sitting next to Puttaraju shop and was selling groundnuts at Kalagondana Halli, Shankranti Fair. At that time, the driver of Tata Motors SFC 407 bearing KA05B 6103 came in a rash and negligent manner, took the vehicle in a reverse direction without indication and dashed against Srimati Madhamma. Due to the impact of the vehicle, Srimati Madhamma sustained grievous injuries and she was shifted to Government Hospital Kanakpura, where she was provided first aid treatment. And during the course of treatment on 1/4/2016, she succumbed to the injuries. It was stated that the claimant spent 1 lakh rupees towards treatment, funeral expenses, and other expenses. It is also stated that claimant was hale and healthy prior to the occurrence of accident, aged 56 years, working as a vendor selling groundnuts and earning 10,000 rupees per month. Claimant is none other than the son of the deceased, who is the sole legal representative. It is claimed that the claimant was dependent on this deceased, who was the sole breadwinner of the family. Respondent 1 and 2 on appearance filed a statement of objection, denied the claim made by the claimants, including age, avocation, involvement of the vehicle, and the negligence attributed to the driver of the offending vehicle. However, respondent number 1 admitted the issuance of insurance policy, but pleaded that there was a violation of terms and conditions of the policy and attributed negligence and it is the policy is subject to the terms and conditions stipulated there. It also pleaded that respondent number 1 is not liable to indemnify respondent number 2. Whereas respondent number 1 denied the involvement of the vehicle and pleaded that the negligence was on behalf of the deceased, who was sitting on the road without there being any permission for approved vending. He also denied the age, avocation, and other aspects pleaded in the claim petition. Both the respondents sought for dismissal of the claim petition. Based on the pleadings, tribunal framed relevant issues for consideration. In order to substantiate the issues and prove the case, claimant examined himself as PW1, got marked exhibits P1 to P12. One eyewitness was examined as PW2, whereas respondent number 1 examined his officer STA FTA of RTO Shantinagar as RW1 and RW2. And the STA FTA RW1, it's official as RW3 and 4. The evidence of RW3 was discarded. Documents were marked as exhibit R1 to R6. On the basis of the material evidence placed on record, both oral and documentary, tribunal awarded total compensation of 4,78,300. With 8% interest, and held respondent 1 and 2 to be jointly and severally liable to pay the compensation. However, directed the insurance company R1 to deposit the compensation And with liberty to recover the same from respondent number 2, owner of the offending vehicle. I have heard learned counsel for both the parties. Peruse the impugned judgment and award. Records Idyamma. It is not in dispute that accident occurred on 20th March 2016, while the deceased was sitting selling groundnuts in the Shankranti fair. The involvement of the offending vehicle, Tata Motor SFC 407, in the occurrence of the accident is not disputed. And to establish the same, claimant has produced exhibits P1 to P12, out of which the police records are P1 to P7, the medical records and election ID with death certificate is produced at P8 to P12. The police records at P1 to P7 clearly disclose the laying of charge sheet, FIR and charge sheet against the driver of the offending vehicle, involvement of the vehicle, and the negligence is rightly attributed against the driver of the offending vehicle. The death having occurred is produced by way of a death certificate. Age is produced through election ID card. So also certain medical bills for the expenses incurred by the deceased. Full stop. Coming to the age, avocation, and income of the deceased as on date of occurrence of accident. The tribunal has taken the income at 7,000 per month as notional income, as no proof of income was produced by the claimant. However, the Legal Services Authority chart describes notional income of rupees 9,500 for the accident year 2016. Same is taken on in the present case. In view of the deceased aged at 56 years, 10% will have to be added towards future prospects. At Madilvadu, which is not being taken by the tribunal, same request to be awarded. Tribunal has deducted 50% towards personal and living expenses, which is rightly calculated. Same is retained. Therefore, the loss of dependency would be 9,500 plus 10%, 10,450. So 50% would be 5,225 into 12 into 9. 9, 5,64,300. As against 3,78,000 awarded by the tribunal. Full stop para. Tribunal has granted consortium at 40,000 and awarded 15,000 towards transportation of dead body, funeral and obsequious ceremonies. I'm in agreement with learned counsel for the appellant that this amount is on the lower side. Consortium awarded 40,000 is correct, but the escalation of 10% is not awarded. Towards funeral expenses, transportation of dead body, together 30,000 requires to be awarded along with 10% escalation, which should be 33,000. Towards medical expenses, tribunal is awarded 45,300, which is on the actual bills produced. Same does not call for interference. In view of the above discussions, the claimant would be entitled to total compensation of
6,86,600.
$6,86,600 as against $4,78,300. Accordingly, I have the following order. Appeal is allowed in part. Claimant is entitled to total compensation of $6,86,600 as against $4,78,300. The all other terms and conditions of the tribunal stand intact. Enhanced balance compensation amount shall be paid by the insurance company with interest at 6% within a period of 4 weeks from the date of receipt of copy of the order. That's all. The order agide. That is already ordered by the tribunal. That is, all other terms are retained.
I am appealing for the appellant, my lord. Lord, in this matter, my lord, the records are necessary. In the previous date, my lord, there was an order to secure the records. But till the records has not been secured, my lord.
Oh, you are appearing Srinivasan? Huh? 58. NY, ನೀವು MY Srinivasan. Who's KN Srinivasan? Registry to secure trial court record.
Date fit.
Here. The records are here.
Please, my lord, any date may be fixed, my lord. I'll argue the matter.
Released on 23rd.
Please, my lord, oblige.
Yes, Srinivasan. Notice to R1 dispense as liabilities admitted by R2. Memo accepted. Released after 2 weeks. The issue notice. Appellant, claimant, issue notice to respondents. Raju, issue notice. Notice. Shantaraj, issue notice. C3, issue notice. Yashvendraya, stay there. Stay kodbeka, kottilla. Kottilva? First time. 50%. Hard learned counsel for the appellant issue notice to respondents. There shall be stay of the operation and execution of the judgment and award dated 31 August 23 in MBC 926 of 19. The file of Principal Senior Civil Judge Additional MACT 3 at Chitradurga. Subject to the appellant insurance company depositing 50% of the award amount within 4 weeks, along with interest before this court.
In judgment, claim amount is stated as 20 lakhs, but in award, claim amount is stated as 22,20,000 ಅಂತ ನೋಟ್ ಹಾಕಿದ್ದಾರೆ. ಅದು ನೋಟ್ ಹಾಕಿದ್ದಾರೆ.
You have the judgment copy with you. $230,000 ಅಂತ ಇದೆ. 304 ಅಲ್ಲ. What is the amount? In the decree, the award 22,20,000 is cost claim ಮಾಡಿದ್ದ ಅದು. So what was claimed?
Claim amount stated as in judgment 20 lakh. But in award, claim amount is stated as 22 lakh 20,000. 20,000. 22 lakh
Correct.
20,000.
Then error. Is there any objection raised?
Not happy questions, just to bring to the. notice.
20 lakhs our claim ಮಾಡಿರೋದು. Judgmental 20 lakhs ಇದೆ. Whereas in the award 22 lakhs ಅಂತ ಇದೆ. But that will not make much of a difference. Whatever 2 lakhs 30 correct. Award of what is claimed by the claimant is differs in judgment and award.
Right? Where should the base
Issue notice.
see? You pass it, I think.
R1 notice dispensed as liability admitted by R2, issue notice to R2. Huh? R2 ne? Memo accepted. Issue notice. Giri Malaya? Yes, sir. Yes, sir. Huh? Claimant. Notice of it. Issue notice.
59 Arjun. 70, 9 PM.
RSC.
It is.
Permission to produce copy of order of assistant commissioner. Nanne banditala.
Yesterday's.
Where is he? Vinay?
Yeah.
Serial number 71, I am for the respondent.
70. Serial number 70. Yes. So you have produced something.
One document you are, that is the rejection of their grant certificate. The subsequent things that we initiated. Their grant certificate has been cancelled.
Today it may not be possible. We'll have it on Monday, Tuesday or Wednesday. Release this matter on 17th, 18th, at request of appellant. Yes.
21, Shashidhar R.
Crossover. Crossover.
Also, there is a bed. Calculation is also very.
Number 10.
ಮಾಡಿದ್ದೀರಾ ಅಶೋಕ್ ಪಾಟೀಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ A4 size. No, this helps instead of wasting time. Calculation will help. You're agreeable with this? No change. Okay. The tribunal has awarded 1682.
Yes, sir.
Now it will become 21,072.
Yes. Now, taken the income of 10,000, they are considering as 50.
11,000.
11,000 plus 40%.
ಏನು ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಬರ್ದಿಲ್ಲ ಯಾವಾಗ?
It's a facility.
17. ಬರ್ಕೊಳ್ಳಿ. This appeal is preferred by the claimants. Questioning the judgment and award passed by the second additional senior civil judge M.A.C.T. Hassan in MVC 655 of 2018. Dated 30th January 2020. His appeal is founded on the premise of inadequate and meager compensation awarded by the tribunal. Brief facts. On 4/12/2017, the Krishnamurthy was proceeding on a motorcycle belonging to respondent number 1. Pillion rider, bro. Was he pillion rider?
Proceeding on motorcycle.
No, was he rider or pillion?
He was the rider.
Proceeding on a motorcycle belonging to respondent number 1.
Yes.
Bearing K13E9359. While he reached near Nerahalli Circle at Aralikatte, motorcycle bearing K13EJ6297 came from the opposite direction in a rash and negligent manner so as to endanger human life and safety. Collided with the vehicle ridden by Sri Krishnamurthy, leading to the occurrence of accident. Full stop. Due to the impact of the accident, the Krishnamurthy suffered serious injuries and was shifted to Arkalgud Government Hospital and further to Mani Hospital, Hassan. And thereafter, despite treatment, he succumbed to the injury. It is stated that claimant spent more than 2 lakhs towards the medical treatment, transportation, and other obsequies. Hence, the claimant filed a claim petition seeking compensation against the respondents. The respondents on a service of notice appeared and filed the detailed statement of objections denied. Appear Adra R1, R2. R1, did he appear and file statement? Let's read that judgment in the trial court.
Appear.
Filed statement contested.
Statement. Examined.
Filed statement.
Filed statement.
Appeared and filed statement denied the claim made by the claimants, including the age, avocation, income, and involvement of the vehicle and the negligence attributed against the rider of the motorcycle. Respondent sought for dismissal of the claim petition. Based on the pleadings, tribunal framed relevant issues for consideration. In order to substantiate the issues and establish the case, claimant examined himself as PW1 and who's PW2? Two witnesses. Court marked exhibits P1 to P10. Whereas respondents did not lead any evidence. On the basis of the material evidence based on record, both oral and documentary, and on hearing the submissions of learned counsel for both parties, tribunal awarded total compensation of 16,82,000. directed the respondent number 2 insurance company pay the compensation. It is a vehement contention of learned counsel for the claimant that the tribunal is head in awarding meager compensation and has not taken into consideration proper income for computation. So also under other heads, the tribunal has awarded meager compensation. On these grounds, the claimant seek enhancement of compensation. Per contra, learned counsel representing the insurance company vehemently contends that there is no error in the judgment and award passed by the tribunal. Same does not call for interference as just and reasonable compensation is awarded by the tribunal by adopting correct methodology of computation, including the future prospects, multiplier, and the deduction. Hence, seeks for dismissal of the claim petition. Full stop. It is not in dispute that accident occurred on 4/12/2017 at 10 p.m. involving two vehicles, in which one of the vehicle was ridden by the deceased Krishnamurthy, and due to the collision in the accident, he succumbed to the injuries. To establish the same, claimant has produced evidence, produced exhibits P1 to P10. The police records clearly indicate the involvement of the vehicle. FIR and charge sheet laid against the rider of the offending vehicle, who was implicated in the criminal case, which is not questioned or challenged. The medical records go to show the deceased having met with the accident and succumbed to the injuries due to the occurrence of the accident. Full stop. The negligence is rightly attributed against the rider of the offending vehicle. Full stop. Now coming to the age, avocation, and income of the deceased as on date of occurrence of accident, which is on 4/12/2017. The tribunal has assessed the income to be 9,000 per month, awarded 40% future prospects by adding the same to the income, and applied the multiplier of 16 as the deceased was aged 32 years, which does not call for interference. So also the deduction towards the personal and living expenses of 1/3 is rightly calculated as there are 3 dependents. This also does not call for interference. The only aspect of interference at the hands of this court would be the income assessed by the tribunal for the accident year of 2017. As per the notional income chart, the 11,000 is stipulated as income for the accident year 2017, whereas the tribunal has taken it as 9,000. Same requires to be enhanced to 11,000. All other calculations and computations made by the tribunal with regard to
Also on the other absorption. Only 40,000.
that I'll come.
Yes.
All other aspects of the compensation on the loss of dependency remains intact, except for enhancement of income from 9,000 to 11,000. Therefore, loss of dependency would be 11,000 plus 40%. $15,400. $10,267 ಬರುತ್ತಾ income. There is some change. Is it correct? 19,000, 71,000, 19,71,264 ಬರುತ್ತೆ. Correct? Huh?
Action was.
All right. 19,071 lakhs, 19,71,264 as against 16 lakhs.
Action we have not taken.
I've also not done. 19,71,264 as against 16,12,800 adopted by the tribunal. Next para. Towards consortium, tribunal is granted 40,000. Towards loss of estate and funeral expenses, 15,000 each is awarded. That is 30,000. Whereas there are 3 dependents who are the deceased, his wife and 2 minor children. Each should be entitled to 40,000 per person as contemplated in the case of Pranay Sethi, thereafter followed in Magma and Satinder Kaur case. Hence 40,000 into 3, 1,20,000 would be the consortium that requires to be awarded, plus 10% escalation for 1 block period would be 12,000. So also loss of estate funeral expenses of 30,000 would attract 10% escalation of 3,000, which should be 33,000. $1,32,000. That's 33. 21 lakhs, 36,000. Any medical expenses awarded? No. So totally 21 lakhs, 36,264 barutte. Correct, madam? 6% ಕೊಟ್ಟಿದ್ದಾರೆ tribunal.
8%
The claimant would be entitled to total compensation of 21 lakh 36,264 as against 16 lakhs 82,800. All of the terms and conditions stipulated by the tribunal stands intact. Appeal is allowed in part. The enhanced compensation shall be paid by the respondent 1 insurance company at 6% interest within a period of 4 weeks in the date of receipt of copy of the order. Respondent number 2 insurance company. Uh,
71 pass over. More
71, I am for the respondent, my lord.
Yes. 71. This coming up for admission or?
And the basis of
For admission. Yes.
According to the case of the basis, this is the defendant's appeal.
Defendant's appeal.
Yes. Concurrent finding.
Suit for
Possession.
Declaration and position.
yes.
Case of the plaintiff that he purchased his social property on 1/2/2007, 2 acres of the deceased Mutaz of survey number 67 part P of Yenna, Garankarte village. Then after purchasing according to him, he applied for the measurement of the land in question on 14/8/2007. And on measurement, he came to know that there is an encroachment of 1 acre of land which he alleged to have purchased. By the submission that as of today, as of the date of the same on 2007, the vendor was not in possession of the land in question. According to Russian case, whereas 7 in specifically says, plaintiff and ourselves with a view to the object purchase portion, purpose of purchase land made an application to the third department, purpose survey was conducted on 14/8/2007. That's record from the Para 7 of the plaintiff.
Para 7 ಏನ್ ಹೇಳಿದ್ದೀರಾ?
6 and 7 plaintiff record ಬಂದಿದೆ.
Para 7 of the plaint, is it?
Plaintiff.
What you said?
Para 6 and 7, plaintiff and herself with a view to fix up the purchased portion of the purchased land made an application to the survey department. The husband survey was conducted on 14/8/2007 by the survey department by issuing the notices to adjacent survey number and landholder, including the defendant. The defendant being the owner of survey number 66, situated to the east of survey number 67/1, was present when the husband was conducted in token of the present at the time of survey. Conducting the act of carrying out the husband's survey in his presence and other landowner, he signed the statement recorded with the surveyor who surveyed the land on that day. At the time of the survey, it was found that the defendant being the owner of survey number 66 had enclosed in survey number 67, that is, in the land purchased by the plaintiff to an extent of 1 acre, which is shown in survey case, and it is the social property in this case. So therefore, my recent submission, as on the date of the sale deed dated 1/2/2007, the vendor did not have the right or did not have the possession to deliver the possession of the land in question. Then I have wrote arrangement in the land in question and I have taken a plea that the suit is barred by limitation because I have been in possession. Even the evidence admits that there is arrangement in the social property of the year of age of more than 15 to 20 years. Therefore, the suit filed by the plaintiff is barred by limitation. Then, according to the another.
When is the suit filed?
Suit was filed on 8/2/2008.
8/2/2000?
2008.
All right.
Then,
So then, where is the plaintiff said that you were in possession at which point of time?
Land purchase to the extent of which is shown in this case, it is to the property. The fact of enforcement of defendant in survey number 67 came to light for the first time on 14/8/2007.
14/8/2007.
As on the date of conducting survey.
Yes, suit is filed in 2008.
My recent submission, whether the vendor had prospective at the time of safety method, possession should have been delivered. Then there is no delivery of possession by the vendor. So therefore, there was during the time of the vendor himself, the defendant wasn't possessed of the land in question. It is the inference that we draw.
No, that is admitted by the plaintiff.
I am admitted. So therefore, suit filed by the plaintiff is part of limitation because I have been in possession 30 years prior to the date of execution of safety.
Suit filed for declaration is barred.
Possession. The possession has to come to him from his vendor. According to his admission, the possession of the social property has not come to him from his vendor. He now, by virtue of the present suit, he is filing the suit for possession. The possession was not delivered.
So what is your defense?
In that kind of possession, it should pass on to him from his vendor.
All right, according to you, when did you get into the property?
30 years prior to the sale deed.
What is the documentary proof?
The document the defense of this man, he was cultivating the land in question from his previous vendor, and so the social property is concerned that he continued the remaining 2 acres of 1.5 acres of land. He was cultivating his Bhuta, and in respect of social property, the landlord had agreed to sell this property, but the sale deed was not executed. There was a oral sale deed in his favor. That is the defense taken by the defendant. However, Mr. Prashant kindly say the PW2 who has conducted the survey, whether he has conducted the entire survey, 16 hours, Prashant kindly see PW2 evidence.
What is the cause of action here?
Pardon?
Cause of action ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Cause of action, 14/8/2007.
That is the date of knowledge of the.
The date of the knowledge encroaching. That is on the date of the husband fixed by the surveyor. Prashant kindly see in order to see the encroachment, the entire survey number 67 has to be measured. PW2, which is surveyor who has conducted the survey, says whether he has not conducted the entire survey number 67. The encroachment has to come to know only the entire land survey number is valid. That's why is the evidence PW2 and page 3 of the evidence. PW2.
Page?
Record. PW2. Deposition of page number 3 of PW.
What is the finding of the trial court?
The trial court found that the suit is not barred by time, and he is the owner by virtue of the same.
You want to read evidence of?
PW2 survey. On the basis of that report only, the present suit has been filed. ಕನ್ನಡದಲ್ಲಿದೆ 2, 3 ದಿಶಾಲಿಪಿ 3.
What is the name of that person?
This person is Viresh Babu, son of Channa Viraya.
Yes.
ಅದರಲ್ಲಿ ದಯವಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ 3 ಬನ್ನಿ. ದಿಶಾಲಿ 3 ಅನ್ನು
Very difficult for me to. Anyway, you read it.
ದಿಶಾಲಿ 3 ಅದು ಕನ್ನಡದಲ್ಲಿದೆ.
First para on top.
ಟಾಪ್ ಇಂದ ಪೇಜ್ ದಿಶಾಲಿ 3 ಅನ್ನು ತಯಾರಿಸಿದ ನಂತರದಲ್ಲಿ ಅದು ಸರ್ವಿಸ್ ಕಿಚನ್. ಸರ್ವೆ ನಂಬರ್ಗಳು ಬದಲಾವಣೆ ಆಗುವ ಸಂಭವ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಸೊ ಸರ್ವೆ ನಂಬರ್ ಚೇಂಜ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಿಶಾಲಿ 4ರಲ್ಲಿ ತೋರಿಸಿದ ಸರ್ವೆ ನಂಬರ್ 67/1 ದಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ 67/1 ಪೂರ್ವ ದಿಕ್ಕಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 66 ಅಂತ ನಮೂದಿಸಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಈಗ ಪೂರ್ವ ದಿಕ್ಕಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 66 it is my property in survey number 66. According to the 60, according to this case, the landowner in survey number 63 has encroached the social property. That is survey number 66. There is no 66 survey number towards east of the property. 67/P. ಉತ್ತರಕ್ಕೆ ಮತ್ತು ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ನಮೂದಿಸಿದೆ ಎಂದರೆ ಸರಿ. He has not mentioned the survey number towards north and west. ಒಪ್ಕೊಳ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 67/1 ಪಶ್ಚಿಮಕ್ಕೆ ಇರುವ ಜಮೀನುಗಳನ್ನು ದಿಶಾಲಿಪಿ 4 ದಿಶಾಲಿಪಿ 4 ರಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದೆ. ಸರ್ವೆ ನಂಬರ್ 66ರ ಎಲ್ಲಾ ಕೋಡುಗಳನ್ನು ಇಂಪಾರ್ಟೆಂಟ್. This sentence is very important. ಸರ್ವೆ ನಂಬರ್ 67ರ ಎಲ್ಲಾ ಕೋಡುಗಳನ್ನು ಅಳತೆ ಮಾಡಿದಾಗ ಮಾತ್ರ ಯಾವ ಕೋಡಿನಲ್ಲಿ ಒತ್ತುವರಿಯಾಗಿದೆ ಅಂತ ತಿಳಿದು ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಎಲ್ಲಾ ಕೋಡುಗಳನ್ನು ಅಳತೆ ಮಾಡಿದ್ದೇನೆ ಅಂತ ದಿಶಾಲಿಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ. I have not mentioned that I have mentioned all the codes in survey number 67. ಒಪ್ಕೊಳ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 67/2 67/3 67/4ರ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣವನ್ನು ದಿಶಾಲಿಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. He has not mentioned the extent in code number 2, 3, 4.
of 67.
67/2, 67/3, 67/4. Referral number 67/1 ಪೂರ್ವ ಪಶ್ಚಿಮ ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣದ ಅಳತೆಯನ್ನು ದಿಶಾನಪಿ 4 ನಮೂದಿಸಿದೆ ಎಂದರೆ ಸರಿ. He has not mentioned the extent of 67/1 of ಪೂರ್ವ ಪಶ್ಚಿಮ ಮೆನ್ಷನ್. ನಾನು ಜಮೀನನ್ನು ಚೈನಿನಲ್ಲಿ ಅಳತೆ ಮಾಡಿದ್ದೇನೆ, ಅದನ್ನು ನಿಶಾನಪಿ 4 ನಮೂದಿಸಿದ್ದೇನೆ. ನಿಶಾನಪಿ 4 ಪೂರ್ವ ಪಶ್ಚಿಮ ಎಷ್ಟು ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ ಎಷ್ಟು ಒತ್ತುವರಿ ಇದೆ ಅಂತ ನಮೂದಿಸಿದೆ ಎಂದರೆ ಸರಿ. This is the defect conducted by the surveyor, and the basis of this merit will be justified. So, insofar as this, the inconsistency of the report, the learned report will not doesn't take into consideration at all. When you see the judgment of the right judge, page 50 minute, paragraph 33.
Come to the issues first. What are the issues framed by the trial court?
Whether page 43, whether plaintiff proves that he is the owner of social property, whether defendant proves that he is in possession of 2 flats 30 years, whether the defendant proves that the plaintiff has executed a sale agreement on 38/2006 and received a sum of ₹50,000, whether the defendant proves that he has also paid a sum of ₹50,000 to plaintiff towards total sale consideration, whether the suit is barred by time, what is the correct court fee to be paid, whether plaintiff is entitled for possession, what are the provisions. Additional issue, whether the plaintiff is bad for one type of this party. The findings were insofar as issue number 1 has been held affirmative, 2, 3, 4, 5 are all held negative.
So issue number 1 and 7.
1 and 7 is held affirmative.
Yes.
I think you lost the paragraph 33.
Paragraph
33 at page 50. What the name of the paragraph 30 was, then I will come to paragraph 30.
Yes.
Defendant has produced the exhibit D1 to D9 to show that he digged borewell and improved the land, and there are grave of ancestors that are laid. But the defendant has not produced the document to show that the owner of social property, only as the owner testimony of freedom people, it cannot be held that defendant is owner of social property. Though he has stated that the plaintiff and her children executed agreement of.
It is also not your case that you are the owner of social property.
Encroachment.
No, you are not the owner. It's not your case that you are the owner.
It is not the case. It's not the case. Defense may not. It's the vendor. She must have morally executed the same thing, but I have not produced the same thing. But the possession is admitted. Possession is admitted.
Your position.
My position, because the very true that I came to the encroachment on 14/8/2007.
That is anyway admitted by the plaintiff in the plaint itself.
Plaintiff itself. So therefore, the possession was also within his vendor by the submission.
Possession was?
Also with his vendor. This possession, it is not his case that after he purchased the property, I have entered into the social property. So therefore, this.
So your case is that the as on date of the plaintiff securing the property and becoming the owner, prior to that itself, you were encroached into the property as an encroacher of the vendor of the plaintiff.
Vendor of the plaintiff.
Which was aware to the plaintiff.
Something that it is plaintiff, he was aware. Because it is not his case. After I purchased it.
So the cause of action will start prior to sale deed to the knowledge of the vendor.
Vendor.
That's your case.
Consciously purchased the property, though that the vendor did not have the possession of this property.
All.
In my case.
Yes.
In paragraph 30, I was reading paragraph 30.
it cannot be held that defendant is the owner of suit scheduled property.
property. Though he has stated to 25 children executed the agreement of sale, but he has not put in the agreement of sale. Not proved that he advanced 50,000 to the plaintiff by examining witnesses. Further, it is pertained to note that the suit filed by defendant and based the agreement of sale for special performance of contract came to dismissed by the Honorable Civil Judge Chennai hearing, stating that the plaintiff defendant has not proved the agreement of sale. Further, he has admitted that he has not preferred any agreed agreement, whereas a suit was filed in May 2010 by the defendant.
OS number?
35 2010.
That is after this suit.
After this.
If you had filed prior to that, then it could have been. So this is.
I can say that the discrepancy in the.
All right, in that suit which you filed, OS 35 of 2010, obviously you must be relying on agreement of sale. Oral agreement of sale. Payment of 50,000. Produce madilla, prove agil.
Only in this case, I can say that this discrepancy, because the entire 767 has not been measured.
But whether have you stated in that suit that possession was handed over to you?
My lord, it was for refund of that amount, 50,000.
I was in possession of the other way, the interest statement will read in the interest statement here. Possession is continued with me. Interest statement.
So that came to be dismissed.
So the claim is para 5 minutes. Of the interest statement.
Yes.
It is true that the vendor of the referred in paragraph 3 of the mail was lecturer at the time of tender, and he was cultivating the land personally on the basis of given to the game, except the extent of 1 acre. That is the pension property. In fact, the extent of 1 acre, that is pension property, was purchased by Mahadeva, the father of the defendant, who has been deceased 5 years back from Shivakumar Swami, the vendor of the sale deed dated 1 to 2007, 30 to 30 years, who was east out of 3 acres to Kuta for valuable consideration. Then itself the possession was given to this defendant's father, but with good faith, the sale deed was not registered with the hope to get it in future. Thus, the father of the defendant was in possession of the pension property since 30 years till his death, and then it is in possession of this defendant after the partition among the members of the joint family. Thus, the vendor of the sale deed was not in possession of the pension property as on the sale date. This fact is also being known to the plaintiff, and the sale deed executed by vendor without possession is a white law. The possession is I reiterate there justify also that our best to that I should be in possession of this issue. Then there are carrying.
Yes.
During the lifetime of Mahadeva, the father of the defendant, after taking possession of the pension property from Shivakumar Swami, Shivakumar Swami is the vendor of the plaintiff. The vendor of sale deed 30 years back, as stated in para 5 of the claim, cultivated the land by growing ragi flower, etc. After the lapse of 5 or 6 years, the father of the defendant converted the land into Arakanat garden by taking borewell, pipe drains, etc. by investing huge amount. Now the Arakanat trees are of 20 to 35 years age, and also number of teak trees have been grown surrounding the said land. Right schedule property. Further, there are various of the defendants assets in this land. After the death of Mahadeva, the father of this defendant, approximately 2.5 years back, taking a due advantage of Mahadeva's death, absence of safety in favor of Mahadeva, and weakness between the brothers of the dependent, vendor Shivkumari of the safety dated 1227 and the advice of some people of the day who are inimical towards this dependent attempted to demand possession of the general property. This dependent denied to give possession of the same since more than 30 years and at this stage, Shivkumari and the plaintiff and her family members colluded with each other have been created the same deed of this without passing consideration and possession, without to the knowledge of this dependent, and father was also changed. The defendant came to know the experience of the deed after Saturday on 14/8/2007, gathered the Panchayat who were aware of the possession of the pension property in the said Panchayat. It was concluded that the plaintiff had to sell the extent of only in pension property in all for rupees 5 lakh as in consideration and rupees 50,000 was expense of criminal documents and also an agreement to be executed by plaintiff in favor of the defendant. This document may not the plaintiff admits, but he says that document has been obtained forcibly. So can you see page 3 of the plaintiff? Page 3 of the plaintiff. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ವಾದ ಪಂಚಾಯತ್ ಎಲ್ಲ ಆಗಿ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಇದು ವಿಡ್ರು ಮೈ ಲಾರ್ಡ್ ಪೇಜ್ 3 ಸಬ್ಸಿಕ್ವೆಂಟ್ ಟು ದಿಸ್ ಸರ್ವೆ subsequent to this survey and the same day the plaintiff and her sons have requested the defendant to give up the possession of the property. The defendant is lodging the request of the plaintiff for one person or the other. After the first survey, the defendant, with the help of the supporters in the village, forced the plaintiff and her sons to give up their rights in the scheduled plan in favor of the defendant. Even though the plaintiff and her sons are not agreed for their demands, they took the signature of the plaintiff and her sons against their well and wish, and the said papers are with the support of the defendant. Here also that survey, the Panchayat is there a bit of the local because of the humanitarian conservation. Then they did it. So therefore the possession matter is admitted. Not I can understand whether I have purchased X and Y encroached it. No. The possession, there was no deliberate possession and the same thing, especially with respect to this 1 acre of land, this is my and moreover I have improved Arakanate and Borvadi is there and the survey sketch method towards each encroachment is shown as 66, not 60. Even PW2 also admit that PW1 method we also admits Arakanate trees are there. PW1 page number lost by the position. Position page 7th row. PW1 page 7 the position.
PW1,
page 7, the position of PW1, page 7.
Yes.
Last paragraph.
Yes.
ನಮ್ಮ ಊರಿನಲ್ಲಿ
Yes.
1 ಎಕರೆ ಭಾಗ ಇದೆ ತೋಟ ಜಮೀನು 8 ಲಕ್ಷ ರೂಪಾಯಿವರೆಗೆ ಬೆಲೆ ಇದೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನಗೆ ಈಗ 31 ವರ್ಷ ವಯಸ್ಸು. ಯಾವ ಜಮೀನಿನಲ್ಲಿ ಇರುವ ಅಡಿಕೆ ಗಿಡಗಳ ವಯಸ್ಸು ಸುಮಾರು 35 ವರ್ಷ ಇರಬಹುದು. ಈ ತರಹದ admission shows that I was in possession even at the time of vendor.
What has the trial court decided on that aspect?
Take you last to paragraph 33 at page 50. The plaintiff has reiterated the same in his examination and also examined the surveyor who has conducted the survey. And in chief examination period, before the survey, he issued notice to the adjacent owners. And on 14 April 2007, he conducted the first survey and found that the landholder of survey number 66 has encroached crucial property. That is wrong. 66 to east illa, but we clear the 66 at the back. And his cross-examination stated that by oversight mentioned there are 66 instead of 60. There is no dispute that on the eastern side of crucial property, land of defendant is situated. Though in plain mentioned as survey number 63, but subsequently plaintiff got amended as survey number 60 instead of 63. Further, defendant has stated that he is in possession of crucial property by virtue of oral sale. Therefore, dispute of boundary on eastern side does not arise. Though PW2 in cross-examination admitted that he has not mentioned the existence of aracanite trees in the crucial property, but PW1 in cross-examination admitted that on 14/7 ರಂದು 10 ಬಸ್ಸು ಅಳತೆ ಮಾಡಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 67 ಮುಂಚೆ ನನಗೆ ಮತ್ತು ಅಕ್ಕಪಕ್ಕದ ಜಮೀನುದಾರರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ಸರಿ. ದಿನಾಂಕ 14/8/2007 ಸರ್ವೇಯರ್ ದಾವಾ ಸುದ್ದಿಗೆ ಅಳತೆ ಮಾಡಲು ಬಂದಿದ್ದರು ಎಂದರೆ ಸರಿ. ಫರ್ದರ್ ಅಡ್ಮಿಟೆಡ್ ದಟ್ OS 68/8ರಲ್ಲಿ ನಾನು ನಿಶಾನಪಿ 5ರ ದೃಢೀಕೃತ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇವೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ದಾವೆಯಲ್ಲಿ ನಾನು ನಿಶಾನಪಿ 5ಅನ್ನು ಖಾಲಿ ಮನೆಯ ಮೇಲೆ ನನ್ನ ಸಹಿ ತೆಗೆದುಕೊಂಡಿದ್ದರು ಎಂದು ನಾನು ಸಾಕ್ಷ್ಯ ಹೇಳಿಲ್ಲ. ಸದರಿ ದಾವೆಯಲ್ಲಿ ನಾನು ಸರ್ವೇರ್ ಸ್ಕೆಚ್ ನನ್ನ ಸಮಕ್ಷಮದಲ್ಲಿ ಸರ್ವೆ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಪಾಠಶಾಲೆ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತೇನೆ ಸರಿ. This admission given by DW1 corroborates the evidence of PW1, PW2 with regard to survey conducted by PW2. The defendant has not challenged the survey conducted by the surveyor. DW1 further admitted that he has tried proof for cancellation of sale in executed in favor of plaintiff. There are no any additional documents to show the defendant is having better title than the plaintiff. It is just a principle of law that possession follows title. Exhibit P8 shows that defendant has not proved the agreement of sale, and suit filed by him came to be dismissed, and defendant has admitted that he has not preferred appeal. Though DW1 stated the surveyor has taken signature and blank figure and not proved the same, not preferred any appeal against the survey conducted by the surveyor. Section 83 of Indian Evidence Act reads as under presumption as to maps or plans made by authority of government. The court should presume that maps or plans purporting to be made by the authority of the central government or any state government were so made and accurate. But maps or plans made for the purpose of any cause must be proved to be accurate. It is clear from a careful reading of section 83 of Indian Evidence Act that if any map or plan is made for purpose of any cause, the said map or plan will have to be proved to be accurate. Here in this case, plaintiff has examined surveyor was produced conducted the first survey. PW2 in his evidence reports with regard to survey conducted by him in the presence of plaintiff and defendant. PW2 subjected to cross-examination, but nothing has been elicited to disprove survey conducted by him. It is contrary to the admission made by him. The plaintiff has proved the accuracy of sketch prepared by surveyor, but the defendant has not challenged exhibit P4, and he himself admitted the survey conducted by PW2. Admission of conducting survey is something different, and pointed out the discrepancy is something different. Particularly, the plaintiff has filed suit on the basis of the when the matter comes to the arena of civil judge, civil court, then when the question of challenging is it correct, then when the court can assess the evidence of PW2 whether it is not or not. The run counsel for the plaintiff read upon citation reporting the error. Plaintiff verified proof of declaration of title and record provision. Plaintiff claiming that he purchased the entire property under registration for valuable reconciliation, alleging trespass by defendant, whereas defendant claiming his possession of 30 years for portion of property under sale date. Sufficient oral and document evidence produced by plaintiff proving his title and possession over crucial property since date of purchase. This is important. Since date of purchase. Here, additionally, as on the date, he is not in possession. None of the documents produced by defendant legal proof is titled over the property. Defendant not denied specific allegation of trespass made against him. Defendant miserably failed to establish that social property was portion of his property. Plaintiff entered for declaration of patent and recovery possession. In present case in hand, also defendant has taken application that defendant in possession of social property more than 30 years and plaintiff and her children execute agreement of same, but not proved the same. On the other hand, plaintiff has produced oral documentary evidence to prove the title and also prove the encroachment for the social property. Hence, the perusal of evidence on record is opinion. It is the opinion that quote plaintiff has proved the defendant is encroached the land basically so and so and so. Therefore, issue number 1 and 7 answer in the question. Kindness is if we reappreciate the evidence of PW2, there is inconsistency. And the encroachment we do not know even north side about west side about one road is the other land is. So unless until measured all the entire land surface 67 is measured.
Already you can read issue number 5.
The defendant's written statement has taken contention that suit of plaintiff is part of limitation, stating that the defendant and his father Mahadev are in possession of social property. This is more than 30 years. The defendant has reiterated the same in his evidence, but defendant has not proved oral statement made in favor of his father of Shivakumar Swami, nor examined any witnesses to prove his lawful possession. Further, defendant has not claimed adverse possession, nor filed any suit for cancellation of stating the plaintiff has purchased crucial property on 1227 and got conducted survey on 14/8/2007 and filed a suit. Therefore, defendant has not convinced the court with right regard to point of limitation. Hence, issue number 5 answer is right. The affidavit court panel, there is no extra findings. Just according to.
Where is the order of the appellate court?
It's a page, first page. 14, the findings is at page 23. The findings at page 23.
All that will take it up in the afternoon.
Retail and
77.
Last week,
Yes. Time kodlilla. I did not give. If you come, and if you are going to ready, I am going to. Did he inform you? Did he inform you?
No.
No. Today. So if you want to argue, you can argue. Because I told him that if you come and argue that you have not been informed, I will hear you and give a date. Okay. 19th and 15th. That's why I gave a date so that both of you are here. Now you are still in possession or you have handed over?
My lords, may I make one submission, my lords?
Yes.
My lord, serial number 72, my lords, I appear for the appellant. We will file a memo of retirement in the next date, my lords.
Fine.
Kindly grant 10 days time to file a memo, my lords. We had informed the appellant also, my lords.
Mediation center report has not settled. You are for the appellant?
Yes, my lords.
You are respondent. They want to retire. Or at request of learned counsel for the appellant, who contends that who submits that she wants to retire from the case due to want of instruction, release this matter next week, date for it. 23rd, released on 23rd.
Much obliged, my lords.
71.
Password or only final year. Just table.
7 members ಇರುತ್ತೆ. ಬೇರೆಲ್ಲ ಅರ್ಜೆಂಟ್ 7 members.
All MFAs.
Both.
Yes. How much more time you will take, Mr. Where is your friend, Mr. Prakash? It's me, Prakash.
71.
Right. I was the respondent.
Yes, sir.
Page 23.
Yes, sir.
The 20 minutes in 70 minutes, my case.
Yes.
Is it admitted that the painting is complete?
Yes, sir.
The children proposal is dated 1/2/2007. Mark that exhibit B11 can be rated as 20 with order of property. It is for the defendant to prove that his father has purchased the fixed property for 30 years back from but the defendant has tried to prove the same. The defendant has not produced any cogent evidence to show that his father had purchased fixed property for 30 years back. But also not produced any documents to show that his father was in possession of fixed property for 30 years, and the defendant failed to prove his father's possession of fixed property from 30 years. It cannot be said that the defendant is one of the property and is in law of possession. These findings are contrary to their admission that in the social property there is a recurrent trace of more than 15 to 20 years. Official error is admitted with PW1, PW2, and it is independent. There is no not in possession in that. My specific question is from asking that the vendor did not have the possession to deliver the possession as defined under the Transfer Property Act. That is my case. The encroachment not starts from painting possession. Encroachment, that is possession is there even prior to purchasing the property. That is my case.
What is the documentary proof
Evidence
of?
both PW1, PW2, PW1. He admits
But he does not admit that you were in possession from 30 years.
the standing trees of 50 to 20 years. Itself demonstrate my possession.
No, has he admitted you have planted the trees?
Because it is itself a possession.
Correct, suit is for possession, but that does not say from which period you are in the property. It is for you to establish.
Again, I read page 7 of the evidence
Of?
the PW1. Cross-examination, PW7.
PW1. Page 7 of.
ನನಗೀಗ 30 ವರ್ಷ ವಯಸ್ಸು ಯಾವ ಜಮೀನಲ್ಲಿ ಇರುವ ಅಡಿಕೆ ಗಿಡಗಳು ವಯಸ್ಸು ಸುಮಾರು 10 ರಿಂದ 15 ವರ್ಷ ಇರಬಹುದು. ಪ್ರತಿವಾದಿಯ ತಂದೆ ತಾಯಿಯರು ಸಾಮಾನ್ಯಗಳು ನಾನು ನೋಡಿದೆ. ಪ್ರತಿವಾದಿ ಅವರದೇ ಜಮೀನು ಇರಬಹುದು ಎಂದು ಸರ್ವೆ ನಂಬರ್ 67 ಬಾರ್ ಒಂದರ ಜಮೀನು ಪಡೆದಿರಬಹುದು. ಒಪ್ಪುತ್ತೆ ಪ್ರತಿವಾದಿಗಳು ಪಡಿಸಿರಬಹುದು. ದಟ್ ಇಸ್ ಕೋರ್ಟ್. ಅವರದೇ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಪಡಿಸಿರಬಹುದು.
What does that mean?
That is silent possession.
No. Read that again. ಪ್ರತಿವಾದಿ ಅವರದೇ ಜಮೀನು ಇರಬಹುದು ಎಂದು ಸರ್ವೆ ನಂಬರ್ 67 ಭಾಗ 1 ಜಮೀನಿನಲ್ಲಿ ಕೊಳವೆ ಬಾವಿ ಕೊರೆಯುತ್ತಿರಬಹುದು. Social property. ಅವ್ರದೇ ಜಮೀನ್ ಅನ್ಕೊಂಡು ಕೊಡ್ತಿರಬಹುದು. So he must have assumed it to be. You must have assumed it to be yours and you may have made the well.
Yes, sir. There is a well in the social property.
ಹೌದು.
Even one suit is for possession, not for injunction.
Admittedly, suit is for possession, seeking possession from you.
Yes, sir.
But he does not say.
Does it flow from the same thing? The question of that. Does it flow from the same thing? Because the vendor did not have the possession. Question 20C, section 5 of the transfer of property. Five, 8 and 54 agreement. Transfer property defined. In the following sections, transfer of property means an act by which a dealing person conveys property in present or in future. Suppose it is a safety. In present that he should have been in possession to transfer the property. The recital doesn't say that so and so property is in occupation of so and so. You are at liberty to occupy in present or in future to one or more other living persons or to himself and once more other living persons and to transfer property which to perform such act. Then also kindly come to section 8 operation transfer. Unless different intention is expressed or necessarily implied, and transfer property passes forthwith through transferring all the interest which the transferor is then capable of passing in property and the legal incidence thereof. According to the Malak, so social property, the transferor did not have the possession. The possession was with me. Therefore, though the recital says when it has excluded social property, since it did not have the possession, there was no delivery of possession of the social property. Then also can we see section 54. There is a transfer of ownership in exchange for a price paid or promised, or part paid or part promised. Say how made. Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of reversion or other intelligibility can be made only by a registered instrument. In the case of tangible property of a value less than 100 rupees, such transfer may be made either by a registered instrument or by delivery of the property. Delivery of tangible property takes place when the seller places the buyer or such person as the director in possession of the property. He has not delivered possession according to the case of Pretty because he came to know that I am in possession after survey was conducted. Therefore, there is a transfer of social property under the deed.
That's not disputed. That's admitted even by the plaintiff.
So therefore, Madam, the suit is the part of the limitation under Article 64 of the Limitation Act.
What do you mean? Limitation Act.
Here, disposition is not forthcoming. 64. For possession of human property based on previous possession and not on title, when the plaintiff by the possession of property has been dispossessed. It is not the case of the plaintiff that he has been dispossessed. 12 years. So the possession, the vendor did not have the possession, and therefore it is not a transfer as defined under section 54 of the Transfer of Property Act. maybe then value also, because on the graveyards and like and ಊಟ ಮಾಡಿದ್ದಾರೆ decrease ಎಲ್ಲ ಇದೆ at least
Yes.
decrease to arrogant back at least to 11 I'm ready to pay. Is it value also?
Ready to pay the? Ready to pay the?
Put ready in equal no because of the all that money has been invested.
For purchase of the property or the trees?
This is the legal. ಅಲ್ಲೇ ಇದೆ
ಏನಲ್ಲೇ ಇದೆ ಗ್ರೇವಿಯರ್ಡ್. Why you did not file any suit? Why you did not claim counter claim? Okay.
No purpose that is because
no, you could have claimed adverse possession. You're in 30 years. 12 years is what is required.
Exactly of the tangible possession for more than 30 years. Why the possession is not there? I have taken the content that I have been in possession 30 years prior to the date of filing. I have taken it to very specific attention in the industry.
All right. What are the further discussions by the appellate court?
The defendant also has not informed holding evidence to show that his father had purchased institutional property about 30 years back. Admittedly, there was no petition stating their father was defendant. Institutional property is an inward property. It shall be transferred only under the registered document as per section 7 of the Discrepancy. As the defendant has not stated sale consideration for his father to purchase the property. Since the property is bodega, it can be presumed that it will be more than 100. Therefore, even if there was any such transfer property in favor of the father of the defendant, we will not get any rights over such property in the absence of registered document. Under such circumstances, the possession of the defendant in the institutional property is not lawful possession, and it cannot be said that the defendant is the owner of the institutional property by having purchased the same about 30 years back. The defendant also mentioned that in a panchayat, the plaintiff has agreed to sell the institutional property to the defendant for ₹5,50,000. The plaintiff and the sons have executed an agreement of sale on 38/2007. Agreed to sell the institutional property for ₹5,50,000. They have received 50,000 as advance, and ₹5,00,000 was paid through 2 checks drawn on State Bank of Mysore, Chennai dated 24. It was agreed that the sale fee is to be excluded in the first executed the first week of December 2007. But during October 2007, the plaintiff and the sons demanded for payment of the sale consideration, threatened that they will not execute the sale if the amount is not paid. Therefore, the defendant has paid ₹5,00,000 the entire sale consideration and received checks. Now the plaintiff and the sons are refusing to execute the deal. The defendant is examined as deliverable, and he has filed affidavit in due of examination chief by retreating all the statement developments with the course of counsel submission. It admitted that he had filed OS number 65/2008 against the plaintiff and the sons claiming the default of the agreement of sale consideration on the agreement of sale. He also deposed that the said suit was dismissed and he has not preferred any appeal. Though the defendant has not stated anything about the said suit in the first statement, he admits having filed suit and it was dismissed. The plaintiff herself has produced judgment and decree of OS number 65/2008, marked as P889, plaintiff of OS 65/2008, marked as P10. On payment of the judgment, it can be seen that the said suit was dismissed on the ground that the defendant has not proved the agreement of sale. Even the defendant also admits that dismissal of the suit, he has not paid a plea against the judgment, and the circumstances can be held that the defendant has failed to prove the agreement of sale executed by plaintiff and the seller. It is a case of plaintiff 48/2007. A property was surveyed when it survey authority in the presence of judges and landowners, including the defendant by issuing notice. The defendant in the written statement itself has admitted the issuance of survey notice and his presence at the time of survey. The such circumstances, it can be held that the defendant was aware about the survey and he was very much present at the time of survey. Even the defendant has not submitted any objection to the survey. He also admits his possession for the social property. Under such circumstances, it can be held that the survey conducted is proper and based on the survey, it can be held that the defendant has encroached on the social property. The plaintiff examined the survey as PW2 and has produced the survey scheme. Mark P4, Mahajan, Mark P5, since the defendant himself has admitted his presence during the survey, it is not objected for this necessary report. It can be held that the defendant has encroached the social property. The defendant also admits his possession in the social property, and he fails to prove his ownership and lawful possession for the social property. As the plaintiff proved title for the social property, and also proved that the defendant has encroached the social property, the plaintiff is entitled for the previous liability proved. Even the defendant has admitted the title of the plaintiff and also admitted that he is in possession of social property. He failed to prove that he is in lawful possession and enjoyment of the social property, having his father purchased the social property from Shukuma about the years back. Even the defendant also failed to prove that the plaintiff and her sons have agreed to sell the social property on the days of 20 days. Now, my lord, the survey method has not been conducted by conducting the entire land in 767. Encroachment would come to, and given that the sketch exhibit P4/26, there is mentioning of 63, not 60. Exhibit P4.
Survey sketch.
Another sketch. Exhibit P4. But pretty similar. Last. P7 ಕೆಳಗಡೆ P7 ಒಂದರಲ್ಲಿ ಈ ಕಲರ್ ಇದೆಯಲ್ಲ ಮೇಲೆ ಕಲರ್ ಅದರಲ್ಲಿ ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ 1 ಎಕರೆ ಪ್ರದೇಶವನ್ನು ಲಾಗ್ ನಂಬರ್ 66 ಬಿರುಳಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿದ್ದಾರೆ. 66 ನಮ್ಮದಲ್ಲ, 60 ಇದ್ದ ಅವಸರ. So therefore the survey itself is defective.
Where is survey 60 here?
Adhe 60 is that. Actually my property 60. According to you 66 adine wrong ante survey sketch is wrong. So therefore entire extending survey 67 is well right. The enforcement should come to know. I have enforced or somebody else enforced. Our prakara, I have read this evidence PW2. Once again, I will read now the evidence of PW2, the right of the sketch. Identification, page 3 of exhibit PW2, in the right of the sketch.
Page?
Page 3 of imposition of PW2. When you work there, PW2. ಈಗ ಕನ್ನಡದಲ್ಲಿ ನಂಬರ್ CH ದಿಶಾಲಿಪಿ 3 ಅದನ್ನ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
What page is page 3?
3 ಮೇಲೆ
Ah.
ಈಶಾನ್ಯ 3 ಘಟಕಗಳು ತಯಾರಿಸಿದ ನಂತರಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ಗಳು ಬದಲಾವಣೆ ಆಗುವ ಸಂಭವ ಇಲ್ಲ ಇದ್ದರೆ ನನ್ನ I have cross-examined the answer to ಈಶಾನ್ಯ ಬಿ 4ರಲ್ಲಿ ತೋರಿಸಿದ ಪ್ರಶ್ನೆ this is the sketch B ಸರ್ವೆ ನಂಬರ್ 67/1 ಪೂರ್ವ ದಿಕ್ಕಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 66 ಅಂತ ನಮೂದಿಸಲಾಗಿದ್ದರೆ ಸರಿ. ಉತ್ತರಕ್ಕೆ ಮತ್ತು ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾರ್ತ್ ಅಂಡ್ ವೆಸ್ಟ್ ನಾರ್ತ್
ಉತ್ತರ ಮತ್ತು
ಪಶ್ಚಿಮ
ವೆಸ್ಟ್.
ಸರ್ವೆ ನಂಬರ್ 67/1 ಪಶ್ಚಿಮಕ್ಕೆ ಇರುವ ಜಮೀನುಗಳನ್ನು ನಿಶಾನ ಪಿ ರಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದೆ. ಪ್ರಶ್ನೆ 20C ಪಶ್ಚಿಮಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಸರ್ವೆ ನಂಬರ್ 67ರ ಎಲ್ಲಾ ಕೋಡ್ಗಳನ್ನು ಅಳತೆ ಮಾಡಿದಾಗ ಮಾತ್ರ ಯಾವ ಕೋಡಿನಲ್ಲಿ ಒತ್ತುವರಿಯಾಗಿದೆ ಅಂತ ತಿಳಿದು ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಸರ್ವೆ ನಂಬರ್ 7 is present and should be known. ಎಲ್ಲಾ ಕೋಡ್ಗಳನ್ನು ಅಳತೆ ಮಾಡಿದ್ದೇನೆ ಅಂತ ನಿಶಾನ ಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸರ್ವೆ ನಂಬರ್ 67/2, 67/3, 67/4 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣವನ್ನು ನಿಶಾನ ಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. is not mentioned the extent of this other codes. ಸರ್ವೆ ನಂಬರ್ 67/1 ಪೂರ್ವ ಪಶ್ಚಿಮ ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ ಅಳತೆಯನ್ನು ನಿಶಾನ ಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. even is not mentioned the extent of the code number. ನಾನು ಜಮೀನನ್ನು ಚೈನಿನಲ್ಲಿ ಅಳತೆ ಮಾಡಿದ್ದೇನೆ, ಅದನ್ನು ನಿಶಾನ ಪಿ 4ರಲ್ಲಿ ನಮೂದಿಸುತ್ತೇನೆ. ನಿಶಾನ ಪಿ 4ರಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ ಎಷ್ಟು ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ ಎಷ್ಟು ಒತ್ತುವರಿ ಇದೆ ಅಂತ ನಮೂದಿಸಲಿದೆ. ಸರ್ವೆ ನಂಬರ್ 67/1 ಅಕ್ಕಪಕ್ಕದ ಜಮೀನನ್ನು ಸಹ ನಾನು ಅಳತೆ ಮಾಡಿದ್ದೇನೆ, ಅದನ್ನು ನಾನು ವರದಿಯಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ. So this is the inconsistency, totally wrong. Quantity survey, identity of the property itself is in doubt. Because he bases his crime on basis of this case. So therefore, both reports are relying upon this report, coming to the conclusion that it is correct, is contributory evidence and report.
Yes.
Here, therefore, what is the CH-16 unproperty about 60. Survey it doesn't mention 60. He mentioned 66. Another 60 is and what the encroachment. All those things are not possible from existing for 50. Therefore, based on this survey scale, coming to the conclusion that the encroachment
What is the substantial question of law?
Whether both the court below are right in law, part between the suit of patent, those native proof, the alleged depend. Whether both the court below are right in law and accepting the service case, though in the alleged service case, the property related is not shown as adjacent land. Second, substitution.
property of the,
Whether both the courts below are right in law and accept the survey sketch. Like a second one. Though in the alleged survey sketch, the property different is not shown as adjacent land. My property is not shown as.
your property is not the subject matter.
Later on, it says in the evidence, 60. I should have mentioned survey number 60, but I have mentioned survey number, schedule. Schedule is paying. East, my property. Depends.
All right, but that is not the subject matter of the suit.
Only the eastern property has been shown as my property is survey number 60. But survey sketch is otherwise.
If it is your case that defendant's property is now being encroached by the plaintiff by virtue of this survey, you are at liberty to go and file a suit.
In the earlier mention, paying as towards east, 66. Amendment ಮಾಡಿ later on, his amended as survey number 60. Therefore, 60 is my below Jameen.
That is on towards the east.
Towards east, my property is there. I have encroached this eastern portion of that.
No, you.
But survey sketch doesn't say 60, but it says 60.
An error of this surveyor who has done it.
So therefore, again survey, because he has not measured the entire land to know the, therefore second subsequent question, whether the court are right in relying upon this survey sketch.
That was not the issue also before the court below. That is not your pleading also in the court below.
The pleading is correct because the plaintiff has to stand on his good leg. He has relied upon this survey sketch only. He has not relied upon the CLD. When it is the case of the plaintiff to prove the encroachment, the mainly has relied upon.
No, in the sale deed, measurement is not there.
It is there. But so that there was no deliberate possession of this crucial property.
That's okay.
According to the plaintiff's evidence.
That's okay. In the he is not relying on the sketch exclusively. Plaintiff is relying on the sale deed of 2007.
Says that encroachment on the basis of the encroachment on the basis of the survey after condition Sadhubastu paid the Adaga. Sadhubastu title may be sale deed, but according to me, there is no delivery. But possession, according to him, he came to know age. Sale deed and another Swadhina is there. Then I came to know on the basis of the sketch.
Right.
That is the base.
Yes.
So therefore, the base for the suit is the sketch, that's what the sketch, not the sale deed.
Yes.
So therefore, this survey conducted by the surveyor, without measuring the entire extent, coming to the conclusion that there is an enforcement, that too, he says towards east, the holder of survey number 63, survey 63 is enforced upon. So therefore, unless that is corrected, then he should have proceeded against the holder of the land in survey 63. Not against him.
Yes.
Sketch ಕೊನೆಗೆ ಪದ ಇದೆ ಆಗತ್ತೆ ಸರ್ವೆ ನಂಬರ್ ಇದನ್ನ ಲಾಸ್ಟ್ ಅಲ್ಲಿ 1 ಎಕರೆ ಪ್ರದೇಶದಲ್ಲಿ ಲಾಗು ನಂಬರ್ 66 ಹಿಡುವಳಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆ ಅವ್ರನ್ನ ಕೇಸ್ ಹಾಕಬೇಕಾಗಿತ್ತು ನನ್ನ ಮೇಲಲ್ಲ
Our ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿದ್ರೆ when it's not affecting you, how are you bothered?
Because it is against because ಈ ಪಕ್ಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ನಾನು 60 ಸರ್ವೆ ನಂಬರ್
60. He is not concerned with 60. Sorry, he is not, the suit claim is not for 60.
It is not for 60, but I have enforced that portion.
Correct.
But sketch is otherwise.
Let it be. That is an ancillary thing. The main important crux of the matter is that he says that he is the owner by virtue of the sale deed. After the survey, he realized that you have encroached his portion. Now he wants possession from you. That is all is the case. Whether he has said you are on the east, in the boundaries. Now after that, he says it should be 66 or 60, find somebody else is ancillary. If that is not affecting you, then you are not affected by the decree.
Because condition by earlier, he said 66. Later on amended it as 60. 60 I am the owner. But survey sketch doesn't say the holder of survey 60 has encroached upon. Schedule nalli ನಾನು ಇವಾಗ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ after amendment. So therefore I am the owner of survey number 60.
Your ownership of survey number 60 is not disputed or by plaintiff.
He has not disputed that the owner of.
He has not infringed on your suit property of the 60.
But still my reference submission now. So relying upon sketch may not be wrong.
All right. That's all, sir. Yes, Mr. Prakash.
My lord, may I make a submission, my lord?
Yes.
My lord, first of all, make a submission that with regard to the disputed property and its situation is not in dispute at all, my lord. Both the parties are having firm in their contention, my lord. And with regard to the much has been argued by my friend with regard to the PW2 evidence, my lord, surveyor. He himself, in his cross-examination, clearly admitted that he was present at the time of conducting this survey, my lord.
Yes, sir. Your colleague is here.
And it has been clearly admitted by the defendant, my lord, that he was present and in his presence only the survey has been conducted. And PW2 has been examined only because there was a mistake in mentioning of the survey number in the survey sketch. For that, we called him and examined, my lord. Actually, this defendant has not disputed by filing any objection to the survey report. It has not been disputed. Its correctness not disputed. That apart, my lord, they are contending in their written statement itself that their father had purchased 1 acre 6 gunta land orally 30 years back. Since then, they are in possession. Thereafter, they filed a suit basing on an agreement, a list have been executed by my vendors on 30th 8/2007, my lord. That is subsequent to my sale. This mind of the defendant can be presumed that by hook or crook, they wanted to gulp this property.
What is the date of your sale deed?
1/2/2007, my lord. 1st February 2007.
What is the agreement of sale of defendant?
30th August 2007, my lord.
Okay.
This clearly goes to show that they wanted to gulp this property, my lord. And the existence of this disputed property, 1 acre 6 gunta, is clearly admitted by the defendant. And also, I came to know that after the survey sketch, it has been encroached by this defendant. Therefore, I was constrained to file this suit for declaration as well as possession, my lord. And I am not stretching my hand over their property. And it is clearly admitted that 1 acre 6 gunta is part of survey number 67/1. Because they have also launched a suit in OS number 35 or 2000. Earlier it was 65 or 2008, my lord. Later it has been transferred to the same court and renumbered as OS number 35 or 2010. Regarding this also, I point out, my lord, I have filed this suit on 8/2/2008, my lord. OS number 94 for 2008. Whereas,
when did you file?
8 February 2008, my lord. They have filed this suit OS number 65 or 8 and renumbered as 35 or 2010 was filed on 10/7/2008, my lord. This judgment of the suit filed by the defendants has been produced and marked as Exhibit P8 before the trial court, my lord.
What's the date?
Date of judgment is 25th July 2011, my lord.
Yes.
The judgment is part of the records, my lord.
Yes.
And it attains finality, my lord. No appeals it has not been challenged by the defendant. Therefore, whatever the findings of the civil code in their suit binds them, my lord. Therein clearly held by the civil court and competent court that the alleged agreement not proved, possession not proved, as they contended since last 30 years they are in possession, etc., etc.
Yes.
The findings are binding and they can't overrule them. Therefore, both the courts have rightly held, because it is not the case of the defendant that they are admitting my ownership, they are not claiming any adverse position, my lord. Two steps they have taken. One is oral purchase by their father, Shukumar Swami, 30 years back. And second one is agreement of sale, which is subsequent to my purchase, my lord. Both have not been proved by adducing competent evidence, my lord, legal evidence. Both the courts clearly held that even in their own suit, the trial court clearly held, my lord. May I draw your lordship's attention to the document Exhibit P8, my lord. It is part of the record. Judgment of the OS number 35 for 2010.
Yes.
I take your lordships to inner page 17, my lord, of the judgment. Para 20.
Yes.
My lord, I may be permitted to read, my lord. That apart, in his cross-examination at the end of the page 14 and beginning of para 15, PW1 has stated as that ನಾನು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣವನ್ನು ಪ್ರತಿವಾದಿಗಳಿಗೆ 5 ಜನ ಗ್ರಾಮಸ್ಥರ ಸಮಕ್ಷಮದಲ್ಲಿ ನೀಡಿದ್ದು ದಿನಾಂಕ 30/8/2007 ಆಗಿದ್ದ ಕ್ರಯದ ಕರಾರು ಪತ್ರ ಗ್ರಾಮಸ್ಥರಾದ ಶಿವಪ್ಪನವರ ಬಳಿ ಇತ್ತು. ನೀಪಿ 1 ಮತ್ತು ನೀಪಿ 2 ಮೊದಲನೇ ಪ್ರತಿವಾದಿಯ ವಶದಲ್ಲಿತ್ತು. ಕ್ರಯದ ಕರಾರಿನಲ್ಲಿ 5 ಲಕ್ಷ ಹಣವನ್ನು ಪಾವತಿಸಿದ ಬಗ್ಗೆ ಮತ್ತು ಆನಂತರ ಮೊದಲನೇ ಪ್ರತಿವಾದಿ ವಶದಲ್ಲಿದ್ದ SBM ಚನ್ನಗಿರಿ ಬ್ಯಾಂಕಿಗೆ ಸಂಬಂಧಿಸಿದ 2 ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ ಪಡೆದ ಬಗ್ಗೆ ಕರಾರು ಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಿಲ್ಲ. It is evident from the said evidence the plaintiff has paid the alleged amount of 5 lakh in the presence of villagers and there is no endorsement in the agreement of sale about making payment of 5 lakh to the defendants. In other words, in order to show about the making of payment of 5 lakh, he has no receipt in that regard. There is no endorsement in the agreement of sale and not produced document to show that he had paid, he had an amount of rupees 5 lakh during October 2007. Further, my lord, besides this, it is also necessary to note that the plaintiffs claim that defendant agreed to sell the land bearing survey number 67/1 for rupees 5 lakh per acre. The property alleged to have been purchased by the plaintiff is 1 acre 6 guntas. If for 1 acre consideration is fixed as 5 lakh, for 1 acre 6 guntas consideration would be 5,75,000. The said fact has been admitted by PW1 at page number 14 of his evidence, which reads that ಸರ್ವೆ ನಂಬರ್ 67/1 ಜಮೀನು ಹದ್ದುಬಸ್ತು ಮಾಡಿದ ಖರ್ಚಿಗೆ 50,000 ರೂಪಾಯಿ ಕೊಡಬೇಕೆಂದು ಮಾತುಕತೆಯಾಗಿತ್ತು. 1 ಎಕರೆಗೆ 5 ಲಕ್ಷದಂತೆ 1 ಎಕರೆ 6 ಗುಂಟೆಗೆ 5,75,000 ರೂಪಾಯಿ ಆಗುತ್ತದೆ ಅಂದರೆ ಸರಿ. Further, my lord, in evidence, it is evident from the above evidence that for 1 acre 6 gunta, the consideration is rupees 5,75,000. In addition to this, the plaintiff has agreed to pay Haddubast charges to the extent of rupees 50,000. It means, according to the plaintiff, he is agreed to pay rupees 6,25,000 to purchase the social property. In the plaint, it is the definite case of the plaintiff that he has paid entire sale consideration to the tune of rupees 5,50,000, and even after receipt of the entire consideration, the defendants failed to execute the sale deed. Further, it is observed, my lord, it is a case of the defendant that after purchase of survey number 67/1 measuring 2 acres 36 guntas on 1/2/2007, submitted an application to the survey department to survey the land purchased by them. Accordingly, the survey officials visited the said survey number and measured the property. This fact has been admitted by PW1 during the course of his cross-examination. We can found the said portion of the cross-examination in the first paragraph that ದಿನಾಂಕ 14/8/2007 ಸರ್ವೆ ಇಲಾಖೆ ಸಂಬಂಧಪಟ್ಟ ಅಧಿಕಾರಿಗಳು ಜಮೀನಿನ ಹದ್ದುಬಸ್ತಿಗಾಗಿ ಬಂದಿದ್ದರು ಎಂದರೆ ಸರಿ, ಜಮೀನನ್ನು ನನ್ನ ಸಮಕ್ಷಮದಲ್ಲಿ ಹದ್ದುಬಸ್ತು ಮಾಡಲಾಯಿತು ಎಂದರೆ ಸರಿ, ಆ ಸಮಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 67/1 ಪೂರ್ವ ಭಾಗದ 1 ಎಕರೆ ಜಮೀನನ್ನು ನಾವು ಅತಿಕ್ರಮಿಸಿದ್ದೇವೆಂದು ವರದಿಯನ್ನು ಮತ್ತು ನಕಾಶೆಯನ್ನು ತಯಾರಿಸಲಾಯಿತು ಎಂದರೆ ಸರಿ, ಸಾಕ್ಷಿ ಒತ್ತುರು ಮಾಡಿರಲಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. When this is the evidence by the defendant in his own suit, my lord, as PW1, because he had filed suit, finding is there, it is clearly admitted. This apart, in this case also, as a DW1 in his cross-examination clearly admitted he was present at the time of survey, and survey sketch is prepared in his presence. Its correctness has not been disputed by the defendant, my lord. Therefore, there is a consensus in the mind that property were existing. What is the extent they have encroached? That aspect of the case has been clearly marshaled by both the courts, my lord, in judicious manner. Therefore, there is, and another aspect, my lord, my purchase is proved, my lord. Sale deed I have produced. That aspect they cannot dispute it. However, whatever the burden lies upon them as per their pleading, failed to prove it by adducing cogent and consistent evidence, my lord. Therefore, both the courts have rightly held and ordered the possession of the encroached land, and under such circumstances, it is very clear, my lord, the intervention or indulgence of this court is not warranted, my lord. In respect of this, my lord, I would like to rely upon the decision, your lordship well aware, reported in 2006 AIR SCW 2404, my lord, wherein it has been observed in the judicial hierarchy. Relevant para is, my lord, 60, my lord, para 60 of the judgment.
Have you produced the judgment?
I am very sorry, my lord, I have not produced it.
ನೀವು ಪ್ಯಾರಾ 60 ಹೇಳಿದ್ರೆ ನಾವು ಎಲ್ಲಿಂದ ಓದೋದು? You can read it.
Yes, well, in judicial hierarchy, finality is absolutely important because that gives certainty to the law. Even in the interest of litigants themselves, it may not be unreasonable to draw a line in respect of the two different categories of litigation where procedure will say at a certain stage the question of the fact have been decided by the lower court and the matter should be allowed to rest where it lies without any further appeal. This may be somewhat harsh to an individual litigant, but in the larger interest of the administration of justice, this view is justically sound and pragmatic. Next parameter, the fact in a series of cases, the Supreme Court was compelled to interfere was because the true legislative intendment and scope of section 100 CPC have neither been appreciated nor applied. A class of judges, while administering law, honestly believe that if they are satisfied that in any second appeal brought before them, evidence has been grossly misappreciated either by the lower appellate court or by both the courts below, it is their duty to interfere because they seem to feel that a decree following upon a gross misappreciation of evidence involves injustice, and it is the duty of the High Court to redress such injustice. It is clear that justice has to be administered in accordance with law. Therefore, my lord, both the courts have not committed any error, my lord, in appreciation of evidence and marshalling the evidence. Legally, they have weighed and decided the matter on their hand. Therefore, I most humbly request, my lord, and pray that the appeal may kindly be dismissed since it has not involved any question of law, my lord, to be decided.
All right. Come on. Already you placed that judgment, let's read.
I will place it.
Yes, you have anything in reply? ಇಲ್ಲ ಅಂದ್ರೆ Food schedule property. 2 acres 36 kunta 67 par 1.
Which is of question? 1 acre consisting of record days and treaties. The case is that they have purchased the property in the production. In the cross examination, they admit that the arrangement and trees are existing, they ranged over 15 to 16 years. Then it can be said that only the defendant, he cannot raise the arrangement.
Can be either the defendant or the plaintiff's vendor.
Vendor, yeah, that is what my suggestion was. There are 3 of the claim. They admits that even they don't know at the time of the purchase of the property who is in question. Their specific case, and they find suit only for possession. That's been the case, Marat. They admit that the project are 3 trees, are raised by the defendant. They are raised to 16 years. When they purchase the land itself. They try to prove the identity of 1 acre of land by producing the service.
Where is it?
Identity of law.
Where is the dispute with regard to identity? Who's disputing?
They claim that I am the defendant.
No, are you disputing that this 1 acre is not belong to the plaintiff?
First, plus they have to stand on their own list.
Sir, I'm asking you, are you disputing this 1 acre is not proved by them and its identity is not proved? So that means 1 acre is not coming within that exhibit P1, that sale deed is not coming.
Only that is what the surveyor specifically admits that he not measure the entire survey number 67. First, he has to measure entire survey number 67 and fix the boundaries of each plot.
Survey number 67 measures totally how many acres?
3 acres, 4 acres and not much. There are 3 sub-survey numbers.
We are not concerned with 67, we are concerned with 67/1. How much that measures?
It's the boundary for survey number 67/1. That's to measure the entire survey number 67. Then you have to fix the boundaries of survey number 67/1. Then you have to find out the encroachment. That exercise is not done by the surveyor. He measured only survey number 67/1. The evidence based by both reports on said survey sketch is improper. Plaintiff not find any amount the sketch before a trial court.
It is not your case that you are owner of survey number 67/1.
I am not the owner of the adjacent land survey number.
How are you concerned?
He claimed that I am encroaching his property. Then you have to prove the identity of it.
No need.
Not proving the identity. First, it may go against the wrong person, they seeking wrong land.
That's why I asked you, you are not claiming any rights in survey number 67/1.
I am not claiming any.
He is not encroached any portion of your land in survey number 60. That's not your case.
I am in question of survey number 60. He is claiming 1 acre in my land.
Which land?
Survey number 60.
60.
On the basis of this wrong.
This is a new argument now you are saying in reply.
Identity prove I will.
No, it is never your argument, nor your pleadings, nor your evidence.
Certainly, it is a novel thing, my lord, he is putting.
Survey number 60, he is claiming 1 acre and your first time you are saying.
Until and unless you prove the identity, Malad, assume that Malad saying.
It is not your case, that's not your defense, that's not your pleadings, that's not your evidence, that is not your argument till now. Yes, Parkole. Third learned counsel for the appellant. And the learned counsel for the respondent. Counsel for the appellant relies on a respondent relies on judgment of the apex court which he intends to file. Release this matter. We file it. Serve a copy. Where is he? Prakash.
I will serve it, my lord, and
Serve a copy on the other side. File it in the court. I will list this matter next week. Relist on 18th.
mobilize.
You have completed argument. No further arguments.
No further arguments.
Yes, next.
This one is the
Yes, both of you are ready?
very medical expenses. Tribunal. They have question with
You argued this earlier?
counsel appearing from the judicial matter, they have already submitted their documents. At my request, matter.
What was the point?
I think, the medical expenses that the petition has to examine this because we want to admit that he has a visiting 3,60,000.
This is that
Yes,
amount which is already. He has produced some judgments. You read that?
Yes, sir. Yes, sir. And submission, so that my first and foremost submission will be that, this condition is not tenable, entertained by this court because it is not found there wrong with the appeal memo of the constitution. Basic. Level is in general comments. That having the regard
That the criminal grossly erred in not awarding any compensation towards medical expenses as the appellant has paid nearly 5 lakhs. This is what they've done. That is not their contention of what they are saying is that the medical, the health insurance what they have got that have been deducted by the court. That is not correct because it cannot be deducted is their question.
Yes.
Clearly, because they have not awarded the total medical expenses we have incurred cannot be the grounds, they should be that the reduction is wrong and the value specific and they have not come before this one and we go to us. That is my answer. Now coming to the other aspects of this case. I mean, the options to the first, they have tried, I look from this honorable judgment to this honorable judgment. I came to know that they have relied upon the judgment of Justice Mohan Shankar Gowda. That is a judgment delivered by a single judge, Your Lordship. 2009 ACG 1448, Your Lordship. Member submissions are that. I'm relying upon the division judgment of this honorable court, which is much later than the 2013 ACJ 2478.
Yes. You have given copy to that?
Wonder, injury, principles of assessment. I'll read the headnote first and then I'll take you to the relevant cases. Principles of assessment, reimbursement of medical expenses, Medicare policy. Medical expenses are classified as pecuniary loss, which means the actual amount which is spent by the claimant for treatment. Whether a claimant can claim medical expenses incurred for treatment of injury sustained in accident under both medical policy and claim petition application under Motor Vehicles Act. Held no. Amount received by claimant under medical policy is required to be deducted from total compensation awardable to the claimant under the medical expenses. With this, I would like to take your lordship to page number 2483, paragraph 16 onwards. In this judgment, the division bench of dishonorable court has discussed other judgments rendered by the division bench of dishonorable court and have come to the conclusion. Paragraph 16. Another single judge of this court in the case of Vin Kumar R. versus Prabhakar HT, Karnataka, was of the view that the claimants cannot get the benefit both under the medical policy as well as under the Act. Learned single judge has to also draw an analogy in the case of a government servant in as much as whatever the amount a government servant gets reimbursed from his employer, the said amount will be deducted from out of the total amount provided by the employers will have to pay it. On the same lines, whatever the amount the claimant gets from any scheme like medical amount, they are to be deducted from the actual claim. Here I would like to take a pause and my submissions, Your Lordship. As a matter of abundant caution, I reiterate to myself that I have to, when I'm assisting the court as an officer of the court, I have to be correct on the best of my ability, correct on the principles of the stand taken by dishonorable court in the judgments, including the judgments to other claimants. Your Lordship, what has been said in all the judgments is that there are certain benefits like life insurance. They have relied upon which is the case and then also frequency of case and come to that as to get for life insurance benefits, gratuity, that is PF, all these benefits cannot be deducted. They become the social security schemes that they are bifurcated in this manner, saying that by paying certain premium amount, if either the injured or the in case of death is elapsed, irrespective of his death, they are bound to get that benefit, then that cannot be deducted here. That means a person called A, he has taken life insurance. That could be obviously for a particular period, like 10 years, 15 years, 20 years, 25 years, based upon whatever we choose in the time plan. If he takes a policy for 15 years, like insurance policy, and if he meets with an accident after 5 years of that taking the policy, whether it is an accidental death or other event, he receives some benefit. Of course, the compensation what he received will be on the little on the higher side so far as life insurance is concerned. So that amount cannot be deducted while awarding a compensation under the motor vehicle accident is the notion given by the Stone Report as well as the Honorable Apex Court in all the judgments. The reason behind it is that when he takes such life insurance policy, whether he meets with an accidental death, motor vehicle accidental death or not, irrespective of that, even if he survives also for a complete period, he is bound to receive that money. Therefore, when there is a certainty of he receiving that money after the completion of the tenure without even meeting with an accident, then that amount cannot be deducted when granting compensation because that's social security scheme. The same is the position in case of gratuity, provident fund, all the government employee, what all the benefits is bound to get, he is bound to get whether he meets with an accident or not. Therefore, that cannot be taken into consideration while granting compensation under the motor vehicle accident case is the notion function. Whereas here in this Mediclaim or health insurance policy, whatever they take, they will be taking the policy for 1 year. Within 1 year, if that event does not happen, say for example, the health is not disturbed or any such injury is not caused to them, they are not going to get back to premium what they have given or how they have given. That is, it is not sure or it is not guaranteed to them that if that event does not happen, then also they are entitled. If the event, irrespective of the fact that whether the event happens or does not happen, they are bound to receive some amount, then that cannot be deducted under the Motor Vehicles Act is the notion. So with this, I take your lordship's analogy and the logical conclusions drawn by this honorable and also honorable exporting. In all the Supreme Court judgments, they have referred to life insurance policies and not the medical policies or the health claim medical expenses. That also has been noted down by the honorable in this judgment, which I will be taking your lordship's to. Now, paragraph 17 also you mentioned. Okay.
Yes.
I need permitted to take little.
Yes.
In so far as the two decisions on which the claimant would place reliance are concerned, the full-fledged ruling of Madhya Pradesh High Court in the case of Kashiram Mathur versus Rajendra Singh has opined that there shall not be any deductions in respect of the amount which is received under life insurance policy, provident fund, family pension, gratuity. In so far as the ex gratia payment is concerned, the full bench of Madhya Pradesh High Court was of the view that it is deductible from the amount of compensation. Madhya Pradesh High Court was of the view that the amount which is receivable by the claimants under the life insurance policy cannot be deducted for the reason that the said amount of insurance is under a contract and for which deceased had paid premiums. The receipt of such amount is not deductible from the damages payable to them. The deceased had not insured himself and paid premiums all the year during his lifetime for the benefit of the tortfeasor. This sum represents his thrift for his own benefit and for the benefit of his family. Thus, the tortfeasor could not seek advantage of this. This is with regard to life insurance. This paragraph what I have read is regarding life insurance. Next paragraph, they discuss about the provident fund. Provident fund constitutes that which the deceased had himself deposited out of his salary for the rainy day. This amount was paid to him and the family would have been benefited even if the deceased were alive. This amount was not an advantage by reason of his death. This principle, as applicable in case of insurance amount, will apply to payment of provident fund. The next paragraph is regarding the gratuity option. They have given the reasons for that. Now I will be taking your lordship's regard with the para number 22.
In all these judgments, I will not relevant enough to take it to the other and stick part like that. Para number 16 in the 22 years. In the case on hand, the facts are almost similar. Unless these facts are read out, I will not be able to convince the honorable court that this case wherein these lordships have dealt with is also a similar case, which is also similar to the present case was my stand, therefore I was reading all those paragraphs. It is in the case on hand, the facts are almost similar. It is not in dispute that in all the claim petitions, the claimants have taken the Mediclaim policies and they have claimed the amount under the policy. We are of the view that the question of the claimants claiming compensation in the claim petitions, which is filed under the Act for the amount expended by them for the treatment, certainly cannot be granted. The medical expenses as observed are classified as pecuniary loss. Pecuniary loss in its context means, I have explained what pecuniary means, the actual amount which is expended by the claimant for treatment. If the said amount has been paid by the insurer under the Mediclaim policy, the question of the claimant claiming the very same amount for the very same purpose, which is inclusive of the expenses which are incurred money for hospitalization and for his treatment, does not arise. Undoubtedly, if the amount which is received by the claimant under the Mediclaim policy falls short of the actual expenses, suppose he receives only 1 lakh, whereas he is incurred 2 lakhs, then that shortfall has to be reimbursed by the insurance company. So, if the amount which is received by the claimant under the Mediclaim policy falls short of the actual expenses expended by him, it is always open for him to show the difference of amount spent from the tribunal. But however, he cannot claim compensation under both the Mediclaim policy as well as the claim petition filed under the Act. The decision of the apex court in Helen C. Revello's case, which I relied upon, was in respect of life insurance policy and not in respect of Mediclaim policy, and therefore the said decision is distinguishable. In this judgment, Your Lordship, I have discussed almost all the judgments available in hand, Your Lordship. So my only submissions are that in this division bench judgment, in view of this division bench judgment, in the year 2013, reported in the year 2013, in ACJ 2478, the judgment rendered by the single judge in the year 2009 ACJ 1448 will not stand. Now coming to the judgments of the honorable Helen case, they have already given conflict.
Yes.
May I take your lordship to that? In this case, also, they have dealt with the life insurance policy and the amount, whether it has to be deducted or not, with that main aspect. Their lordships of the apex court have also distinguished and said what can be deducted. It is available in the handbook itself, Your Lordship. First, A. Life insurance amount received by heirs on account of the victim's death held not deductible. Common law principle of adjusting the pecuniary advantages coming from whatever source by reason of death held has to be repeated in such cases as the pecuniary advantages coming on account of accidental death and not other forms of death. Hence, here they specifically say provident fund, family pension, cash funds, shares, fixed advantages cannot be termed as pecuniary advantages for the purposes of motor vehicles act. Now, with this, Your Lordship, the Lordships have said in the bottom paragraph 10. So far as the general principle of estimating damages under the common law is concerned, the pecuniary loss can be ascertained only by balancing on one hand the loss to the claimant of the future pecuniary benefits that would have accrued to him, but for the death with the pecuniary advantage, which from whatever source comes to him by reason of the death. In other words, it is the balancing of loss and gain of the claimant occasioned by the death. But this has to change its color to the extent statute intends to. Now, may I take Your Lordships the relevant see,
last 5 lines of the same paragraph. Thus, under the present act,
Yes.
thus, under the present act, whatever pecuniary advantage is received by the claimant from whatever source would only be if it comes to the claimant on account of accidental death and not other forms of death. It would not include that which the claimant receives on account of other forms of death, which he would have received even apart from accidental death. As such, pecuniary advantage will have no correlation with the accidental death for which compensation is computed. This concept I have clarified in further lines. However, where the employer insures his employee as against injury or death arising out of an accident, any amount received out of such insurance on the happening of such incident may be an amount liable for deduction. Here, in the present case, Your Lordship, here they have said about the death instance. The present case is a case of injury. The employer has even extended the benefit of health insurance. Whatever he has paid under the health insurance has been paid, that appear he cannot claim it under the Motor Vehicles Act. Legislature has taken note of such contingency through the proviso to section 95. Under it, the liability of the injury is excluded in respect of the injury or death arising out of the course of the death. Now, next, an employee contributing to a provident fund on this case are entitled to the amount of the fund irrespective of the accidental death. That's what it has been even in the judgment history of account article 95. The same concept here also that I have explained. Similarly, the heirs receive family pension even otherwise than the accidental death. Family pension they are bound to receive whether he meets with an accidental death or not. After his death, which is a natural thing, phenomenon. After his death, also they are bound to receive. So that cannot be deducted merely because he met with an motor vehicle accident and he received that amount under the social scheme. There is no correlation. What the logics are trying to say in all these developments that the logic, the amount what he has received must find a correlation with the amount which is sought. Here in the present case, the amount what he has received, there is a clear correlation. Because of the injury and the commitment, he has received that. Had there not been any injury or the accident treatment, that amount he would not have received. So when there is an direct correlation between the receipt of amount and the actual occurrence, expenses that have to be deducted. If there is no correlation, that is irrespective of that incident happening, if he is bound to get that amount and he received that amount, that cannot be said that because he has received that amount, this I am not bound to pay under the Motor Vehicle Act, he cannot say so, because he is bound to receive that amount. So there was no correlation. What for he has taken life insurance, he has taken from his life. In case of any death, that death is certain for everyone, but it will not happen. When it happens, nobody knows. That is the reason why he takes that life insurance. And whether he dies from a motor vehicle accident or some other death, that amount is bound to receive. Therefore, they cannot be deducted while paying amount under the compensation under the motor vehicle accident case. There is no correlation between the two. Similarly, the amount of life insurance policy is receivable by the claimant, not on account of any accidental death, but otherwise on the insured's death. Death is only a step or contingency in terms of the contract to receive the amount. Similarly, any cash, bank balance, shares, fixed deposits, etc., though are all pecuniary advantage receivable by the heir on account of past death, but all these have no correlation with the amount receivable under the statute, occasioned only on account of accidental death. Such an amount cannot come within the periphery of the Motor Vehicles Act to be termed as pecuniary advantage liable for deduction. I think it's not 33 and 35. 33 and 35. Only few lines are kind of Thus, we could not include that which the claimant receives on account of other forms of death that he will have received even apart from the accidental death. Thus, Such a pecuniary advantage will have no correlation to the accidental death for which compensation is computed. Any amount received or receivable not only upon of accidental death, but that which would have come to the claimant even otherwise would not be construed to be the pecuniary advantage liable for deduction. This is very clear. I have to make myself very clear. Such pecuniary advantage, thus such pecuniary advantage will have no correlation to the accidental death for which the compensation comes. Any amount received or receivable not only on account of the accidental death, but that which would have come to the claimant even otherwise could not be considered to be the pecuniary advantage liable for deduction. That means pecuniary advantage which we receive are only liable for deduction and not other things which he is bound to be received even otherwise of the accident. However, when the employer insures his employee as against injury or death arising out of an accident, any amount received out of such insurance on the happening of such incident may be an amount liable for deduction. However, our legislature has taken note of such contingency to the branch of Section 1995. Under it, the liability of the insured is excluded in respect of injury or death arising out of and in the course of employment. This is based on the principle that the claimant from the happening of the same incidents may not gain twice from two sources. Thus, it is excluded that either through the wisdom of the legislature or through the principle of loss and gain reduction, not to give gain to the claimant twice arising from the same transaction, that is, same accident. It is significant to record here in both the sources, that is, either in the motor vehicle act or from the employer, the compensation received by the individual with claimant is either statutory or through the security of the employer security for his employee, but in both cases he receives the amount without his contribution. Thus, an amount earned out of one's labor or contribution towards one's wealth savings, etc., either for himself or his family, which such person knows under the law, has to go to his heirs after his death, either by succession or under a will, would be said to be the pecuniary gain only on account of one's accidental death. This, of course, is a pecuniary gain, but how this is included or to be balanced out of the amount received as compensation under the Motor Vehicles Act. There is no correlation between the two amounts, not even remotely. How can an amount of loss and gain of one contract be made applicable to the loss and gain of another contract? Similarly, how an amount receivable under a statute has any correlation with an amount earned by individual? Principle of loss and gain has to be on the same plane, within the same sphere of course subject to the contract, to the contrary or any provision of law. Now we will actually with this last page, 112. Para 36, you'll actually change it. Here they are very, very clear that life insurance, no deductible so far as the life insurance amount is concerned.
Where are you reading?
Para 36, last week, 5 lines. You have no hesitation to practice that. The set of decisions which apply to the principle of life should be accepted.
Yes.
That is principle of no reduction of life insurance amount should be accepted. That they have accepted. Yes, so far as life insurance amount is concerned, that cannot be deducted. That's what that they have accepted. The other set, which interpreted to deduct, is deducted. For all these considerations, we have no hesitation for that. Such high courts were wrong in deducting the amount paid or paid under life insurance by giving a restricted meaning to the provisions of the Motor Vehicles Act. Basing mostly on the language of English statutes and not taking into consideration the changed language and the intents of the. So basically, in this case, your object, the insurance company was in a plea challenging that neighbors, legal heirs of the deceased had received the amount more than what the claimant that received that amount under the life insurance scheme. Therefore, they are not entitled for the compensation under the Motor Vehicles Act because life is one and death is one. So, what the amount have received under the life insurance that they have been under the Motor Vehicle Accident case,
that more than that they have received the life insurance scheme. Therefore, they are not entitled under this act also because it's a social beneficial and whoever is beneficial social legislation also.
Yes.
That was their contention. So the honorable apex court said that life insurance amount what they have received cannot be deducted. The reasons they have given because they would have given the premiums on every date of hearing and that life insurance amount is applicable to him irrespective of his accident or accidental death. Therefore, that was a certain benefit which was going to receive it back. But in this judgment, as I read it here, they have also made it clear in the earlier judgments also that medical, Mediclaim or health insurance, whenever they take such policies, they are not sure of getting back what they have paid or any benefit after that period is over. If I take my health policy today for a year, I pay some premium of 25,000. If within 1 year nothing happens to me, I can't ask the insurance companies to pay some benefit out of that, whatever the premium I have paid. That amount is gone, is gone. So during that period, if something happens and if you incur a loss of medical expenses of more than 25 lakhs or anything, the insurance under the health policy may be only 25 lakhs, so you have taken the assured, amount under that policy. Beyond that, if you have incurred, then only that difference amount you can claim under the motor vehicle accident case. Not that 25 lakhs also because I have paid that premium once, therefore I am account for that also and this 25 also that amounts to bonanza is not that much. That is what I was saying. Also, to simplify myself, your object, any amount paid as premium for certain schemes, which you are bound to get that amount irrespective of this happening or non happening of that motor vehicle accident, then that amount if you receive that cannot be deducted under the motor vehicle side.
Whether this division bench judgment of our High Court is challenged?
No, I am not coming. It's not. None division bench High Court challenge. In all the judgments, your Lordship, in two judgments are there. Courtesy of case is 1 to 9, I need to commit to read only 2 lines. Your Lordship.
Which one?
Yes, I mean. The judgments of the Honorable Apex Court that have dealt with the amount payable under the social security schemes, that is life insurance, gratuity, people community, provident fund, etc., and not with regard to medical expenses.
All right, read it.
Yes. This was also the appeal, insurance company, insurance company had come in appeal, your Lordship. Their lawsuits under the head of the C, your Lordship, they have said about the object of the act, your Lordship. Object of, okay, if you say the defendants from being deprived of the source of their maintenance and are not responsible to provide them with the means as they are available to them in pre-accident period. The intention is not to overcompensate. Like 36 and 37, you want to then update about this of the meaning on this aspect. 36, I am kindly committed to video.
Yes.
We are in full agreement with the observations made in the case of Helen Referral. That principle of balancing between losses and gains by reason of debt to arrive at the amount of compensation is a general rule. But what is more important is that such receipts by the claimants must have some correlation with the accidental death by reason of which alone the claimants have received the amounts. Now, by reason of this accident alone, they have received that medical expenses. Otherwise, they would not have received it. So those can be deducted and not other things.
We do not think it would be necessary for us to go into the question of distinction made between the provisions of the Capital Accidents Act and the Motor Vehicles Act. According to the decision referred to in the earlier part of this judgment, it is clear that the amount on account of social security as may have been received must have a nexus or relation with the accidental injury or death so far to be deductible from the amount of compensation. There must be some correlation between the amount received and the accidental death, or it may be the same sphere, only that it can be deducted, that's what they say. Here in the present case, I'm repeating that, kindly be excused, Lord. In the present case, he received the medical expenses because of the accidental injuries and the treatment, otherwise he would not have received. There must be some correlation between the amount received and the accidental death, or it may be the same sphere. Absence, the amount received shall not be deducted. Absence means if there is no correlation, then that amount cannot be deducted. In case of life insurance gratuity program, there is no correlation. Irrespective of the accidental death, also they are going to receive. There is no correlation between the accidental death and the amounts which they are going to receive even after the death of that person, irrespective of the fact that he dies in a motor vehicle accident or otherwise. If there is a direct correlation, then that amount has to be deducted, the absolute. Thus, the amount received on account of insurance policy of the receipt cannot be deducted from the amount of compensation to note of the receipt of the insurance amount is declarated due to premature death of the insured. So far as other items in respect of which you are accounting for the insurance company has regularly urged, for example, some allowance paid to the children and Mrs. Patricia Mahajan under the social security system. No correlation of those receipts with the accidental death has been shown, much less established, apart from the fact that contribution comes from different sources for contributing the fund, out of which payment on account of social security system is paid. One of the constituents of the fund is that the deduction from the income of the conductors. We feel that the High Court has rightly disallowed deduction on account of receipts under the insurance policy. Life insurance policy here. Even otherwise also, the lordships have gone bit ahead of this in the foregrounds of this interpretation of life insurance. That said that even otherwise also looking to the death of some person, some social organization, some NGOs, they come forward and pay some amount out of saving, even that can also be cannot be deducted. If the proposition receives from whatever source that is included in this waiver, receive from whatever source, whatever source they receive that amount, if it has got no correlation, then that amount cannot be deducted. If there is a correlation between what he receives and the incident happened, which is claiming, then that has to be deducted.
Yes.
If the proposition, the receipts from whatever source they different so widely that they cover all the receipts which may come into the hands of the claimants in view of the mere death of the victim, it will only defeat the purpose of the act, providing for just compensation account of accidental death. Such gains may be on account of savings or other investment except made by the deceased. Do not go to the benefit of the wrongdoer, and the claimant should not be left worse off if he had never taken an insurance policy or had not made investments for future return. So in this case also, the Honorable Apex Court has allowed the appeal of the insurance company in part. Only like they have deducted the other expenses, other benefits what he has received, having the core relation with that is, I come to the ratio payment then again. I don't see the having some correlation with the accidental death and deductible. And not be also. So this has also been explained in 2016 judgment of the Honorable Apex Court.
Yes.
Read the description. Land description is coming to ground sea. Pay to the 630 about 630.
Yes.
The principal discernible
Yes.
from the exposition in tenancy revenue case is that if the amount would be due to the dependents of the deceased even otherwise. These are the crux of the submission. If the amount would be due to the dependents of the deceased even otherwise, the same shall not be deductible from the compensation amount payable under 1988, that is MV approach. That means, otherwise of this, if it is, would be due to the dependents of the even otherwise, if they are not paid to the name, then that has to be. The amount which they are bound to receive it, even otherwise of that cannot be deducted. The amount which they are not able to receive, even otherwise, that is, unless the incident happens, they are not going to get that money, then that has to be. Is the theme of this judgment. And para 17 also. Para 17, 18, and 24. This again, the object of object followed object in mind when avoiding the compensation. What is discussed? Agree that as it may, the term compensation has not been defined in the 1988 Act. By interpreting the drafting and this means recompense the claimants for the possible loss suffered or benefits suffered due to sudden and untimely death of their family member as a result of motor accident. Two cardinal principles run through the provision of the Motor Vehicles Act in the matter of determination of compensation. Firstly, the measure of compensation must be just and adequate. Secondly, no double benefit should be passed on to the claimants in the matter of award of compensation. These are the two principles that have to be kept in mind is what the lordship succession consider the matters in the Motor Vehicles Act and award of compensation. Section 168 of the Act makes that first principle explicit. Subsection 1 of that provision makes clear that the amount of compensation must be just. What just means fair, adequate, and reasonable. It has been derived from the Latin word.
Yes.
And in para 18, they have repeated the same. First, people like say, what is different than what even otherwise that cannot be deducted. What they does not have got has to be deducted. So my every submission for that, putting all these judgments, they have considered or the judgment which they have relied upon by the appellant's counsel, they are all pertaining to the amount payable in case of life insurance, gratuity, GPA, other benefits, not in case of medical expenses. Okay. The division judgment of this one, the Supreme Court has made it very clear. The Allen's Referral case and all the things they are concerned with life insurance and not with the medical expenses. So for medical expenses are concerned, once it is paid by the concerned city, he cannot claim it again from the tribunal is what they have also. So my own submissions are that in the present case, this father has admitted that the medical bill itself is paragraph 14 of the judgment of object, 2,80,905.
14. In this case, the petitioner's guardian who has given evidence that PW1 admits that under health insurance policy scheme, they have received the amount of 3,60,000. So after that's 14 days. So after taking such amount, the remaining amount petitioner is entitled to the same. In this case, petitioner has produced medical bills at Exhibit 11 and is showing 15 medical bills, and the total of the same is shown as 2,18,901. So when he has received that amount, he is not eligible for any amount.
Yes.
Therefore, my other submissions are that for the judgment of the tribunal deducting that amount what he has received, or not considering the amount what he has received at his education, just in fact eligible to that list, and therefore they are not eligible for it. Compensation from this.
Okay. Yes, what do you say?
In paragraph 14 of the judgment. Paragraph 14 of the trial court judgment. Lordship may kindly value. Judgment reads that they have received 3,60,000 from the insurance company. But you do not find such a statement being available in the trial court record. What it says is total bill submitted is 3,60,382. Which may refer to the evidence got like PW1. She says she was reimbursed with 2,96,181 out of the total bill submitted for 3,60,382. Meaning thereby, not the entire amount submitted for reimbursement was paid.
No, all right. Are you asking that balance amount to be given?
No. You have great difference.
No. Your argument now is that you have submitted a bill for 380, you have given 290. Then if you want balance amount, that can be considered.
My exhibition is this earlier judgment, division bench judgment, referred to in 30. Our High Court judgment, which we are referred to, it says the provisions of subrogation is applicable. Your lordship will discuss this Manish Gupta's case. That is division bench judgment from 2013. The entire judgment is there. It makes an analogy with damages to the motor vehicle. If I take, for example, the policy for damages, it makes a comparison with that. And if I receive a portion out of the total damages, then balance has to be paid. This is how it makes a comparison. My humble submission is that is on the basis of subrogation. Subrogation principle means this law of subrogation will apply in property damage only. That too, when there is total loss. I will rely on that financial statement of the contributory statement of the other. First, he has now referred to this. And the division bench in 2013 has relied on the same principle, that is subrogation principle. So it should be a balanced amount. My humble submission is subrogation principle is not applicable in injury cases. Number one. Number two, law of subrogation will apply when there is total loss of property damage. Say for example, Melor. I will probably submit what is there in the financial statement.
No. The simple thing now is you relied on Helen Ribella and others.
Yes.
Where life insurance and other things of pecuniary damages, contractual and statutory. Yes, stick on to that. Reply if you want to on what she has stated. You want to take time, go through this judgment, understand it. If you have any better judgment, or if you want to distinguish, if that is distinguished by any other apex court judgment, please produce that and argue that. Subrogation is nowhere there here. There is no subrogation. Simple thing what the Supreme Court has held, right from Helen Rebolo and thereafter Sebastian Lacra and other cases, and just a single judge of this court. Now that is now controverted by her by saying there is a distinction between life insurance, gratuity, pension, and other things, and mediclaim. So you have to now substantiate your arguments on mediclaim whether it also should be not deducted, and they have to pay because you have paid according to you have paid premium.
Only the health policy is not only for accident only. It is even otherwise the ailment also it is.
Correct. So that.
So it is not accidental injury only, it is not paid. For health policy is taken for all type of health ailments. I am covered. I am covered, including accidental health problem. So one of the criteria is accidental injury also. All other forms.
So what these courts have said and what she's trying to say is that you cannot have a double
Yes.
compensation, and you cannot. What they also said that it is not a luxury to have double remedy of compensation. But if you are able to distinguish it,
I will do that.
Tuesday.
So, sentence I can. So my counsel has said that it was a health insurance policy available for all the areas. No, I don't dispute it. Even we have taken health policies. You know, within that particular span of time, say 1 year or 2 years or 3 years, if nothing happens, you are not bound to receive any benefits out of that policy. If you are bound to receive the benefits, whether that applies or doesn't talk about that becomes a social scheme, and that amount what you receive afterwards, that should not be deducted.
What about the prudence of the claimant to have made a investment on his health and accident?
Because he will not be aware that he will meet the motor vehicle accident or what, even some health upsets like some heart problems, some other major health issues comes up, then he has to pay out of his pocket. So which he will not be having to pay such huge medical bills. So with that intention, you would be taking that medical policy or health insurance policies, not with the intention that now benefits going to come at today. If you are moving, no such policies are in existence there in India. So therefore, once you receive the benefit under such policy, you can't again actually claim it as a motor vehicle accident merely because there happens to be a motor vehicle accident and you sustain injuries and incurred expenses. Is my answer.
Heard learned counsel for both parties. Counsel for the appellant seeks time to reply. Release this matter on 18th, 17th, 18th. No, dear, just go through it. I think it requires some kind of a application of mind because this is, I think.
I will try to distinguish you. Now, because of two conflicting judgments of revision, what should be done by your lordship?
No, even if there is a conflicting judgment of the division bench, if there is a judgment of the apex court.
No. There are two conflicting judgments of the co-equal bench. Say, for example, she has referred to one division bench. Another division bench.
Of this court. Of this court.
I have already division bench judgment.
Yes.
Which refers to 3 judges judgment of the apex court.
Yes.
That is the. So, if there are two conflicting judgments of this court of equal strength, then which is to be followed?
No, that's why I am telling you, please have the patience of hearing. Even if there is conflicting judgment of division bench of this court of the same strength, if there is a division bench and one of it is already referred to a larger branch of the Supreme Court or this court, the larger bench will certainly apply.
Yes, that is why.
So say so.
Rated judgment refers to 3 judges, the rated judgment of the apex court.
Bring that and let distinguish it. Bring that and distinguish it. Yes.
24.
Yes, Shivanna. Negligence at fault. Huh? ಯಾವ ವೆಹಿಕಲ್ ಅಲ್ಲಿ ಹೋಗ್ತಿದ್ರು? He put the brakes. ಹಿಂದ್ಗಡೆಯಿಂದ ಬಂದು ಹೊಡೆದಿದೆ. Who's before the court? Ilri, Ali, tribunal before who? The rider of the bike or the motor, the car? He's... All right. So, compensation is awarded. The compensation of 4,47,000 is awarded. What is your defense? One of the aspects. Rate of interest. Contributory negligence ಆಗ್ಬೇಕು. So rate of interest 8%. Rate of accident is 2018. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? So only you are in appeal. You are not in appeal. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 8,500. What is the amount should have been taken? 12,500. Why you are not? ನೀವು ಹಾಕಿಲ್ವಾ? ಯಾಕೆ? ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿ ನೀವು ನೋಟಿಸ್ ತಗೊಂಡ ತಕ್ಷಣ ಅಟ್ಲೀಸ್ಟ್ ಹಾಕ್ಬಾರ್ದಾಗಿತ್ತು. All right. Anyway, you don't want to file, what I can do about it. Yes. He cannot be put into a worse situation just because coming to the court. Next. %15 disability, na? Huh? 16%. Disability 15.
48% to the right value.
Hmm.
16%.
16.
16. 14% has been considered.
So 15 is the multiplier. Huh?
Multiplier 40 years. Then fracture of right finger, fracture of bones of right leg. Digital under.
The total compensation awarded is 4,47,600. So on other heads, you are not disputing.
They are disputing only on FIR or charge sheet, the very the driver of the car, not examined before the tribunal, except not insurance company examining the officer of the company. No independent eyewitness has been examined before the fact.
Even if 10% is taken as contributory negligence on your client, the amount will come to 4,02,840. If that amount is increased because of the income, you get more than 1 lakh extra, for 5,48,000. We'll go and file. Advice court in that. You need advice from court or from waiting for some wind. Could have filed. 10% contributory negligence ತಕೊಂಡು ಮಾಡಬಹುದು. Let him file. Just compensation ಕೊಡಬೇಕಲ್ರಿ. So even if that amount of calculation of 548 ಬಂದು ನಾವು contributory negligence ಕೊಟ್ಟರು ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಬರುತ್ತೆ ಅವ್ರಿಗೆ. See, for the fault of lawyer, you cannot penalize the client. Our insurance ಮಾಡಿಲ್ಲ. No, you file now also. You file. Take time. Go and file it. Consider it. Consider his submission also. He also wins. You also win. Win-win situation for both. Because there's a lot of difference. 8,000 Allah, 12,500. You will keep quiet. Go and file. Our insurance company ಎಷ್ಟು ಬೇಕಾದಷ್ಟು ದುಡ್ಡು ಮಾಡ್ತಾರಲ್ಲ, client ಸಿಕ್ಕುತ್ತಲ್ಲ. Case of injury, then a counsel for the respondent seeks time. Counsel for the appellant is ready to go on with the matter. It's a last chance, relist after 2 weeks. File ಮಾಡಿ ಒಂದು on the same day it can be. Date ಬೇಡ ರೀ, ನೀವು ಫೈಲ್ ಮಾಡ್ರಿ ಫಸ್ಟ್, ಡೇಟ್ ಕೊಟ್ರೆ ನೀವು ಆಗಲ್ಲ. ನೀವು ಫೈಲ್ ಮಾಡಿ, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಹಾ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅಲ್ಲ, ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅವರು ಮುಂಚೆನೆ ಹೇಳ್ಬೇಕಾಗಿತ್ತಲ್ಲ ನೀವು. These are all social welfare legislation. ಹೇಳ್ರಿ ಅವಾಗ, ಇವಾಗ even if I accept his appeal and say, because what he's saying is right, you have to maintain a distance, and even under the Motor Vehicles Act and the rules, you have to travel at a distance of, you are seeing the, if in the car, the wheels of the.
Without giving any indication whether the driver of the car seeing the hump, to apply the brake abruptly. Therefore, is a radar of motorcycle gas tank.
That is why you have not maintained a distance. Whether it is an indicator or no indicator, if you had maintained the distance and you are not traveling in an enormous speed, you can still stop anta his argument. Correct? And India lagala. If you go to Western countries and even Dubai, the rules are that when you are driving the car, you are supposed to drive in a manner at least 15 feet, so that you can see while driving the wheels of the rear wheel of the front car. That becomes 15 feet. So even if he puts brake, if you are maintaining the speed shown in the road, there won't be accident. But highway, definitely you can't restrict that. Even at that 15 feet also, with that speed you can't. You file it, let's. It's easy to dispose of. In 10 minutes I can dispose it. Your zone is.
75.
ಇದೇನು ಲೋಕ್ ಅದಾಲತ್ ಆಗಲ್ವಾ? 75 realist next week at request. No representation for appellant.
81.
Right. ಯಾರು ನಿಮ್ಮ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇಲ್ವಲ್ಲ? You are challenging the fixed on you.
I for the claimant.
No.
The driver of the vehicle without driving license. The criminal said the liability is not part of the vehicle. I challenge the.
So you want to shift it to the insurance company? Prashant ilwala, Keshav Prashant.
Keshav Prashant is no more matters. Already local file.
ಒಂದು ಅಫೇರ್ ಆಗ್ತಿದ್ರಲ್ರಿ, ಆ ಉದ್ದಕ್ಕೆ ಬರ್ತಿದ್ರಲ್ಲ ಅವರೇ ಅಲ್ವಾ? ವಾಟ್ ಹ್ಯಾಪನ್ ಟು ಹಿಮ್? ಹೌದಾ, ಯಾವಾಗ? ಲಾಸ್ಟ್ ಇಯರ್, ಲಾಸ್ಟ್ ಮೇ. Because he had appeared before me the earlier round of. Yeah, which insurance?
Reliance General Insurance Company already
ಯಾರು? Vestur. Betsur. Leonard Counsel, Betsur. He shown as counsel for R2. R1. What about Reliance? R2 yaru?
R2 is the owner of the vehicle already
manager as R1. And delete the name of Learned Counsel H.N. Keshava Prasant from the cost list. Relist. Week after next. Huh? Torsa you hedaitalla.
Respond number 2 notice already served.
Idiyalla. Idiyalri R2 General Manager Reliance Insurance. ಯಾರು R2? What is the name? ಇಲ್ಲಿ ತಪ್ಪಕ್ಕೆ ತೋರಿಸಿದಾರಲ್ಲ, ಇಲ್ಲಿ ತಪ್ಪಕ್ಕೆ ತೋರಿಸಿದ್ರು. Registry to show R2 as Gangadhar B, and rectify the cost list. Serve ಆಗಿದೆಯಾ? Yes. Next week. No representation. We list next week. Same. Also same. Exclusively MFA, so that there is no interference of this RSC, because that consumes a lot of time. 1 or 2 days exclusively, only MFA instead of RSC, so that more cases can be disposed.